for appropriate orders, my lord, where your lordship will see that the appeal was admitted and directions were passed for filing of affidavits.
Which application?
My lord, can 2,
And what is can 1?
stay, the main stay application in connection with the appeal.
So they were asked to file opposition to both the applications.
No. My lord, in the stay application, lordship will see the order, my lord, order in can 2.
Just a moment.
Yes, my lord.
Three words. Please. Yes, Mr. Shah.
My lord, during the pendency of the appeal, where we have challenged the maintainability of the writ petition, an order has been passed by the writ court, my lord. Lordship will see that order that is adversely affecting us. My lord, page 14, my lord. Page 14 of the can 2.
Yes, that is the writ petition filed by the private respondent.
Private respondent.
That has been
They are, my lord, they want to hear the writ petition during the pendency of the appeal. How that can be? We have challenged in the appeal, we have challenged the very maintainability of the writ petition. Affidavits are to be filed, that direction is there. Notwithstanding that, an order comes. I don't know how this order was passed, my lord.
this order by the appeal court was passed in an order passed. This appeal was preferred challenging.
By the private respondent, Dr. Tulsi Dasan.
That we understand.
My lord.
This is pertaining to the same writ petition.
Yes, my lord. Challenging the 2 orders passed in the writ petition, where certain orders were passed, those orders were under challenge in the appeal. Now the appeal court entertained the matter, directed filing of affidavits, my lord. When the appeal court is to hear the matter, they want to proceed with the writ petition, and this order is coming. How this can proceed at all, my lord, during the pendency of the appeal? They are saying that In the event no affidavit in opposition is filed, in case the writ petition shall be taken up as unopposed motion. How? I am asking myself this question, my lord. How?
Can you show us the order against which the appeal was preferred?
Yes, my lord. In the stay application, 2 orders.
So in
Match,
what
match
you are
the,
doing? You are
yes.
praying that stay the operation of the subsequent order of the writ court.
Yes, my lord. Now, because that will affect us adversely, how can the writ court proceed when the appeal is pending? Affidavit and directions are there.
You are not party to that?
I am party.
You are party.
Yes.
So why didn't you raise that point, Mr. Samant?
Maintainability
Milord.
point raised before the writ court.
My lord, I was not there on that date and the order was passed. I failed to understand how my learned friend Mr. Prasant could ask for this prayer.
No, my learning friend appeared, page 76.
No, how did I appear? Where is my name? Where is my name?
Page 76.
Page 14. 14 of Can 2. Where did I appear when this order was passed?
Maintainability question, that is to be seen.
No, Mr. Prasant, he is saying that in the order annexed at page 14 of Can 2,
Well,
his name does not feature.
his,
I was not there.
his junior appeared.
Very good. Then, if the writ petition is pending
My lord.
and we are in ceasing of the appeal,
My lord,
then at least
stay was refused, my lord. Stay was not granted when he moved stay application earlier.
stay of what?
Stay of the parent order passed by the honorable single judge.
Very good. That the demolition, that sealing of hotel and demolition, these were the two issues.
Yes, these were the key.
So far as demolition was concerned, single judge did not pass any interim order.
No. That has been stayed.
That has been said, but the sealing has not been disturbed.
Disturbed. It was continued.
So that the division bench has stayed the order of demolition.
No.
No, demolition order was also stayed by the writ court, my lord, in the second order.
There were 2 orders. The writ court, where is the previous order of the order which has been challenged in
76.
page 76.
Stay application 76. Mr. Samanta appeared. Never raised the point of.
Yeah.
I have raised the point of maintainability. How my learned friend is saying so?
624. So there were 2 orders. Sealing was not touched,
Not touched.
and demolition proceeding did not stay. However, demolition proceeding not to be carried out. Very good.
Yes.
So demolition was stopped.
Yes. Sealing continues.
So Mr. Samanto has now come against that portion of continuance of sealing.
No, my lord.
This is a fresh order.
No, let us understand, Mr. Samanto, why did you prefer the appeal against
The appeal was preferred on 2 grounds, my lord. Your lordship is absolutely right. One part was relating to the continuance of the sealing. Relating to continuance of the sealing. Your lordship is absolutely right. The other portion was, my lord, maintainability of the writ petition. That is reflected in the order passed by the appeal court in the first order passed, my lord, which is at page 10.
It should be taken before the honorable.
let us understand. Mr. Prasant, we are seeing this for the first time. Now.
Yes, my lord, I am sorry.
That will appear from the order of the appeal court that maintainability point was taken.
Yes, my lord. Page 10. Can 2, page 10.
Can 2, page 10. Yes. Where you have said that?
My lord, paragraph 5 and paragraph 6. Page 11, paragraph 5, paragraph 6. Lordship has got it,
The
Lord.
maintainability of the writ petition in the appeal.
Yes,
Trial.
not before the trial. Lordship is absolutely correct.
So very good. Now the appeal court has called for evidence from you.
My lord.
So Mr. Prashant, don't proceed with the writ petition. Next
I'm
cycle
grateful.
be in
I'm
June.
grateful.
This is fresh cause of action. Lordship kindly appreciate.
No, Mr. Prashant, unless,
This order passed by
Mr. Prashant, just one clarification. You have been asked to use affidavits to the two applications.
My lord.
So you will use your affidavit
Already I filed.
Huh?
Already I filed, my lord.
already filed. So he will give a reply to the same. And the next circuit bench is in June. So in any fact, you cannot continue with the writ petition during this pendency.
Practically no order is required by this honorable court.
Right, we understand that. So what we do is, we
I
will,
will file objection to this scan application.
or you have filed your objection to what?
This can, first can, second can.
No, objection to the first can has been filed.
Yes.
One. State,
Yes.
you have filed the evidence.
Yes.
You will,
State has not filed, my lord. State has not filed a reply. Affidavit in opposition, state has not yet filed.
Filed.
But I have
Yeah.
filed respondent number
I
4.
copy to the.
I have
who is that respondent?
approved by municipal council.
1 and 2, I am seeking
You have
extension,
filed-
madam. For 1 and 2, I seek extension of time to file up.
Now,
So
see,
you did that.
Yes.
Within this time, you complete all the evidence, we keep the appeal returnable on the date the next session is held.
My
Lordship.
And on that date, the writ petition, if is taken, appeal court will be in ceasing. We are not passing any order. You argue your points before the writ court. Mr. Samanto will be there.
My lord, one thing, my lord, subject to my lord's pleasure. My lord, this order, if it is allowed to remain, my lord, kindly seize the order, my lord. Page 14.
We have seen that Mr. Samanto,
Yes, my lord.
the-
My lord, the question is, my lord, I'm just asking myself a very humble question, my lord. My lord, when the maintainability of the writ petition is under challenge, can they say that we want to proceed with the writ petition and the appeal court is still in ceasing of the matter? I'm asking myself this question.
we are not proceeding, Mr. Samanto.
They are. They are, because they are closing my affidavits. They are closing my affidavits, my lord. What remains after that? It will be heard as an uncontested matter, my lord. How that can happen?
will only decide the issue.
How that can happen, my lord?
Mr.
Is
Mr.
it not prejudicing us, non-suiting us?
Yes.
My lord, ultimately, subject to approval, my lord, ultimately the matter will be decided by the single bench only.
Oh, Mr. Prashant, this order which has been passed on 18th March 2025.
My lord. It's a fresh cause of action. My respectful submission is he has to file another.
18th March 2025 is an order not in appeal. It is not challenged in the appeal.
Yes.
As you are saying, it is a fresh cause of action.
Yes.
Kindly, you have to rule out the multifarious proceedings. Now, Mr. Prashant, we will say that the appeal will be heard on that day, and thereafter, subject whatever order is passed, you would be at liberty to proceed with the writ petition. What problem is that?
There is no problem, my lord. But thing is that they want to delay the proceedings. By filing this appeal, they want to delay the writ proceedings.
If the writ petition is heard out, Mr. Prashant, during pendency of the appeal itself will become.
My lord, that's the only point I've taken before my lords.
If writ is disposed of, entire matter goes.
Then what is the utility of having an arbitration, Mr. Prashant?
Granted, my respectful submission is that they are granted. They want to delay the.
We will only observe that the appeal will be heard first, and thereafter you can take steps for continuing with the writ petition.
But
Delay the proceedings, that is the reason. Because maintainability, admittedly, maintainability point of.
When is it returnable, sir, your motion? When is the writ petition returnable? Have you mentioned?
There is a direction for filing affidavit.
There is a direction for liberty to mention.
Yes.
So that they can proceed on unopposed application.
Anyhow, whether the writ petition or appeal, that will be taken only in the month of June.
But
Only-
Lord, my heard first.
I need to file reply, let the matter be fixed in the month of June. That matter will be taken up.
but if the writ petition is disposed of per chance, then appeal becomes in.
No,
So
it's not against the maintainability.
you understand that?
Appeal is against the interim order.
Uh-huh.
Interim order is not granted. Therefore,
What?
writ can be.
Appeal is pending.
See page 40.
Miller, I have seen Miller, I have seen.
You see, direction is reply, the opposition reply matter will be listed before next circuit bench, that is in June. And we liberty to mention at that time.
Miller,
In the event no opposition is filed.
Miller. My respectful submission is that Miller,
Mr. Samanto,
don't take it
you
out.
file your opposition to the writ petition.
Yes.
May I make a humble submission, subject to my lord's pleasure? May
Yes.
I, my lord, if the writ petition maintainability goes already, your lordship will once kindly come back, my lord. I'm sorry to have to trouble your lordship with this such a small matter, but my lordship kindly comes to page 11, my lord.
No, Mr. Samanto, we will say
Yes.
that this order has been brought to our notice. We are directing the petitioner to file the affidavit in opposition to the writ petition. Writ petition on the reopening date, they will use a reply. Thereafter, only then liberty will be available to him. In the meantime, the appeal will be heard. Finished. Liberty will be there once you do not file the affidavit in opposition to the writ petition within the time.
Milord, may I make a very humble submission, Milord? Your lordship is well conversant with that. When the appeal court is in ceasing of the matter and maintainability of the writ petition is there, and Milord, your lordship will see they have relied upon a document.
You are wanting a stay upon the writ court not to proceed with the writ petition.
Until the appeal is disposed of, only this much. And
Sir,
Milord, I'm not asking for that. I'm asking only one thing, Milord, that if I file my affidavit in opposition, Milord, if I don't, then it will be unopposed motion. Milord, my rights go.
So we are saying you will file the opposition.
Milord, if I file the opposition, I will not get the benefit of the opposition that is being filed in the appeal court. There certain documents will come out from which, Milord, my writ petition will be stronger.
You will get the copies of the opposition. What is your problem?
Unless I get the documents from the authorities in the appeal court, Milord, lordship kindly comes to the order of Milord the appeal. Lordship kindly comes once. Page Milord 12. Paragraph 11, Milord. Milord, it reads like this, Milord. After considering the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that the respective contentions of the parties are required to be brought on record through affidavits. Accordingly, the respondent shall file their affidavits in opposition on or before March 20, 2025. Affidavit in reply, if any, thereto shall be filed on or before April 8, 2025. Milord, affidavit has not been filed by the all the respondents. They are asking for further time. Then, Milord, the respondent numbers 2 and 3, while filing their affidavit in opposition, must and should disclose copy of the original notification. Milord, the notification on the basis of which the writ petition has been filed, and the decision of the appropriate authority in support thereof, if any, with regard to the document disclosed at page 24 to the said petition, in addition to whatever stand they will take in the light of the case made out in the writ petition. Milord, there we have taken the point that the writ petition is not maintainable because they have given a document which is from a newspaper.
You understand that, Mr. Samanto? Kindly come to the order of 18th March of the writ court.
Yes,
What
Milord.
said?
Milord, could that order have been passed? I'm asking myself this question, Milord. Could that order have been passed?
That was passed in your presence, Mr. Samanto.
Milord, that's why the appeal, that's why, Milord, in the appeal I have preferred the application.
Yes, we appreciate that.
Milord, if a wrong has been done by the writ court during the pendency of the appeal, can I not come before my lord? I'm only asking myself this question. Can I not come before the court and say that this is a mistake on the part of the writ court and this should be corrected? I cannot go back to the writ court because the writ court has passed an order. Where do I go? Appeal court. I'm before my lord.
This order is not under challenge in the present appeal. Try
Should
to
it? Is it required to be? My lord, is it required to be?
But it's বলছে যে এটা যদি হয়ে যায় তখন ইনফ্রাস্ট্রাকচার চলবে। সেটা তো অন্য ব্রড প্রিন্সিপাল।
My lord, I believe I could explain to my lord why I am aggrieved, my lord, and why I am before my lord. At least my rights should be protected because the writ cannot proceed without the appeal being heard out first.
You can challenge this order, my lord. 18 March order, he has not.
By a fresh.
Prashant, but there can be two adjudication by two forum.
My lord,
When the appeal is you are not agreeing to that will be compelling us to pass any order against that.
my lord,
We cannot allow simultaneous proceedings pertaining to the same issue.
the lordship
We can request you, but you don't proceed with the writ petition till the matter is taken up and decided in the appeal, that interim
My
one.
lord, they want to drag the issue, my lord.
We are fixing the date,
My lord, kindly do it that way.
fixing the date, and
No objection.
till such date, you will not proceed with the text, you will not mention the matter for, because this has been already said, that liberty to mention, so that it will, unopposed motion it will come. Then it
That
will
is dangerous, my lord. That is dangerous, my lord. That part of the order, my lord, your lordship will kindly protect me by saying that it will not take effect. Only this portion. I'm not asking for anything else.
Before the, raise this point before the honorable single bench, number one. Number two, they don't want to file objection to the writ petition.
We will record that.
We
Ashok.
need, my lord, we need documents from the authorities on which we will be filing the opposition.
Clarity, very clear. Actually sleeping on the
Mr.
Within a week, we will file, my lord.
And my lord, your lordship knows, when Supreme Court is taking up a matter, the High Court normally says what? Sorry, I cannot touch the matter because Supreme Court is in session of the matter. Here, the writ court should have said so. Instead of that, the writ court has been persuaded. This order could not have been passed. It could not have seen the light of day.
No stay.
What no stay? If the writ petition maintainability is under challenge, specifically ordered by the appeal court,
You have to raise
it
before-
is required.
The records reveal that the present appeal was preferred. Challenging,
Two appeals against two orders.
two appeals, no?
Two appeals, 71, 72.
That the above appeals were preferred. Which are the orders? One is 18th November.
18 November, and the other one is, Lord, 14/11. 14/11 and 18/11. My lord, your lordship comes to page 3 of my CAN application, CAN 2.
Can 2,
Yes, my lord.
page 3.
Yes, my lord. First paragraph.
records reveal that challenging orders dated 14 November 2024 and 18th November 2024 passed by the learned single judge in the writ petition being WPA number 625 of 2024. The above appeals being MAT 71 of 24 and MAT 72 of 24 were preferred. You are which respondent in that writ petition?
Respondent
You
number
are
4.
the private respondent number 4.
The respondent number
4.
by the respondent number 4 in the said writ petition. By an order, by an order dated 20th February 2025, a coordinate a coordinate bench of this court
The order is set out, my lord, at page 3 itself. I have set out the order.
a coordinate bench of this court directed the parties to exchange their affidavits in the stay applications, two stay applications
One,
In-
two, in 71 and 72.
filed in the respective appeals.
Copy to the madam.
Respective appeals. Stop. You have filed this can to when?
Can 2, my lord, has been filed day before yesterday, probably. My learned junior can tell, my lord.
Subsequent thereto, the writ petition appeared before the learned single judge on 18th March 2025.
My lord, upon mentioning by them, not like that.
When the court directed the parties, directed the appearing respondents to peremptorily file the affidavit in opposition by 2 weeks. It was also observed by 2 weeks. The court further granted liberty to the writ petitioner to mention the matter in the event no affidavit in opposition is filed within the time directed. And that upon such mentioning, the writ petition shall be taken up as an unopposed motion against the respondents. Bringing the said order dated 18th March 2025 an application for appropriate order. You have filed in both the appeals or in only one appeal?
In
Only
only one
one.
appeal, lord. Prolixity of proceeding in one appeal.
Filed, क्या लिखा? Bringing the said an application for appropriate order being can 2 of 2025 has been filed in connection with the appeal being MAT 71.
Lord, actually, in the cause title, it is 71 and 72.
An application for appropriate order being can such and such has been filed. Mr. Samanto, learned advocate appearing for the appellant.
Private respondent. Appellant, private respondent.
Yes, Your Honor. Appellant stroke respondent number 4 in the writ petition submits that the said submits that the appellant would not be in a position to file an affidavit in opposition without considering the affidavits in opposition filed on behalf of the respective respondents in the present appeal.
I'm grateful.
Will not be able to file an affidavit in opposition without noting the stand of the respective respondents, without noting the stand of the respondents in their respective affidavits in opposition. So he submits that in the event stop in the event the stop till date you have filed opposition
I filed for the municipal council also filed.
and you are agreeing till date the administration has not filed their affidavit.
PDS. That's one number 4. I have filed.
क्या लिखा आपने? Stop. Mr. Sarang, you will not till affidavits in opposition has filed. Stop. In the event, in the event during pendency of the present appeal, the writ petition is heard out as an unopposed motion. The appellant would be severely prejudiced, more so when the point of maintainability, more so when the point of maintainability, more so when the appeal court, more so when the writ petition itself is not maintainable. Mr. Samanto's submission, huh? This is Mr. Samant. Mr. Prashant Learned Advocate appearing for the writ petitioner stroke respondent number 1 hearing submits that pursuant to the earlier direction of a coordinate, pursuant to the earlier direction, pursuant to the earlier order dated 20th February 2025, the said respondent had already filed affidavits in opposition to the stay to opposition.
But covering both.
Calcutta has already filed an affidavit in opposition dealing with the averments made in both the stay applications filed in connection with the appeal. Stop. You have given copy to him?
Yes, yes.
Copies of the same today?
No, not that.
Achha, go on. Stop. The petition, stop. He further, please listen, then you submit. Let me record, he further submits that till date no affidavit in reply has been filed on behalf of the appellant, and it is their intent to keep the writ petition pending, to delay the disposal of the writ petition. He further submits that the point of maintainability was also not urged on behalf of the appellant when the writ petition was taken up for hearing on 18th March 2025. Stop. Mr. Kumar Learned Advocate appearing for the
Respondent number 4. Municipal council.
respondent number 4, prays for extension of
No, I filed.
appearing for the respondent number 4 submits that pursuant to the earlier direction of this court, the said respondent had already filed affidavits in opposition.
In connection with CAN 1 and
Both affidavits in opposition. In opposition dealing with the averments made in both the stay applications, and copy of the same has also been served
already been served.
Also been served upon the appellant.
Yes.
Mr.
Yesterday.
appearing for the
2 and 3 in this.
2 and respondent number 2 and 3 hearing. However, prays for extension of time to file the affidavit in opposition dealing with the affidavits in opposition to the stay applications. We have heard the learned advocates on record and perused the earlier order dated 20th February 2025. Stop. Admittedly, please. It appears that the present appeals have been preferred, challenging interim directions issued by the learned writ court. Interim directions issued passed by the learned single judge on 14 November and 16 November. Would
18.
date those
18.
18 November. And in the event the writ petition is heard and disposed of in the meantime, the appeal itself would become infructuous.
I am grateful.
In view thereof, we request the learned single judge in view thereof, the writ petition should not be heard till the present appeals are disposed of by the Honorable Appeal Court.
I am grateful, madam.
Stop. List the appeal for further consideration before the next available circuit bench on 10th June 2025, subject to the convenience of the court. Stop. The parties would be, in the meantime, the parties would also be at liberty to exchange their affidavits. In the applications being can 1 of 20 you have filed opposition, na? Acha. Next brother. In the meantime, stop. The time to file the affidavits in opposition by the respondent number
2 and 3 herein.
2 and 3 is extended for a period of 2 weeks from date.
Oh, much obliged.
Stop. Thereafter, the respondent, the appellant hearing, the appellant shall file affidavits in reply to the oppositions filed on behalf of the respective respondents within a week thereafter.
My lord, 2 weeks. 2 weeks, my lord, because I'll have to coordinate from Calcutta. 2 weeks.
Such direction is mandatory, and such direction
Peremptory, my lord.
Such direction, the time fixed towards exchange of affidavits is peremptory. Abhi list the matter. Stop.
Point I raised.
Yes.
I say that the order dated 18 March 2025. It's a first cause of action. No separate appeal has to be filed.
Mr. Prashant further submits that the application be can too. Further submits that no appeal has been preferred against the order dated 18th March 2025 by the appellant hearing. And as such, Blair has filed that line.
Investigation for its signature, no appeal has been filed against the order dated 18th March 2025 by the appellate.
appellant here. Full stop. वो उनका ये statement उनके ऊपर लगे.
Therefore, this scan is not maintained.
And that as such, the application being can 2 of material is not maintainable.
If he wants to file an affidavit to opposition to this can, my lord, let him. If he wants to file an affidavit in opposition,
Next para लिख दूं. The time to file affidavit in opposition to the subsequent application filed by the appellant being can 2 of 2025. Now the time now, the respondents would be at, the respondents are further directed.
It will further delay. It will further delay.
he himself wanted it.
Opposition will be a record here.
Yes.
So you exchange your evidence to the stay application and it will be.
Yes. Nothing is required.
Yes. Chalo, Mr. Moyo, Samanto, don't take advantage of the delay.
No, I will not, my lord. I am peremptory, your lordship's order, I will maintain, my lord.
Do what your client will do.
Mobilization.
Not at all, my lord. Here, if the writ petition goes, my lord, then everything goes. Khatam. Bye-bye to my learned friend's submissions.
You have to be in a very relaxed mood. Today, I can please no worry.
My lord, I cannot hear, lordship. Lordship,
Yes, you are in a relaxed mode. Today, you are work in High Court. Oh, the Hasi Dago.
I'm grateful, my lord. I'm very grateful, lordships.
I was making.
Yes, it's not this.
I was, my lord had directed us.
No, she will file the paperwork at the matter we have.
No, this matter was heard, my lord. This is
Number 1, na?
no.
My lord, only one thing, my lord. 2 weeks your lordship has given, my lord.
You are on 1.
Achha.
What is it? Government, he says, Mr. Kumar says service is not yet complete. What we will do, tell us. So what we will do, Mr.
Maybe also I have sent everything I have done.
So এই ফাইলটা তো 1 নম্বরে। Mr. Kumar, we could have disposed of the matter. We applied our mind to it. We extensively heard. Now you are taking a technical point. What can?
This is absolutely by the government of India who have to take a decision. We are nowhere to pay a role in it.
She has already served also.
Mail also I have sent the lordship, entire file I have paid in a PDF and sent everything to the.
Did they file opposition in the before the tribunal?
No,
They did not file.
we have only the 2, 3 and 4 as well.
Only they have filed. They did not appear before the tribunal also.
Who?
The government of India, no council appeared. No council appeared.
Okay, very good. We will not await their due. She will file paperwork enclosing all the no further liberty for opposition because you are the answerable. We can record in spite of service, they are not appearing. Service is complete.
Yes, by mail also, email also I have sent it.
Miss Nagland, the present writ petition has been preferred. Challenging an order dated 4th of March 2025 passed by the learned tribunal in the original application, bracket A in short, comma, OA, bracket close being OA. 7 OA number 351/00720/2019. We have heard Mrs. Nag, learned advocate appearing, learned senior advocate appearing for the petitioners, and Mr. Kumar, learned advocate
2, 3 and 4.
appearing for the respondent numbers 2, 3, and 4. No one Yes, Mr. Jaipal, what is this matter?
Mr. Khan yesterday. Order of remand, I have questioned lordship for this first instance of the
Pass over, then we are up to the matter. Yes, call the next matter.
item number 5.
My lord, I was making my submissions, my lord.
Yes,
I will just hand over a list of dates, my lord, which I have prepared as indicated by the honorable court. I should give you. Well, how? My lord had indicated that we should give the relevant dates. In fact, my lord, that admission letter which your lordship was had queried regarding, it is also part of the paper book because I went through the paper book yesterday again. So my lord will see that is at page 218 of the paper book.
that's just. বাবা, লিপিটা একটু sharpen করে দাও না, পেন্সিল। Two hundred and 18.
Yes, my lord, I have page 218, my lord, because I was, no, this is the same that what is set out by, no, I'm not on that, I'm saying.
Miss Na, do you want to apprise us anything further?
Yes.
Then Mr. Chakraborty, let us hear her out, then so that you can meet the argument.
Yes,
Yes.
Lordship. In points, I will say my submission. Lordship, I have submitted that none of the complainants were examined. I've shown from the charge sheet that they
No, that is not. None of the complainants.
yes, kindly come to the charge sheet. Lordship.
Complainants means those two persons who went to his house.
3%. 3% were the complainant.
No, just let us check out.
Page number.
Yeah,
That is the
no. Verbal complaint was, let us come to the, verbal complaint was by K. Samuel and Rajiv Vishwas. No third person.
Lordship, may kindly come to 98.
No, you please come to 230.
230. This is the order.
Yes,
I am telling about the charge sheet.
yes, quoting the charge.
Incorrect. That is incorrect thing. That's what I am submitting. Kindly come to page number 98. Kindly come to that.
Page 98.
Yes, Your Lordship. Part of the charge sheet.
This is legible also. Where you are reading?
Annexure 3.
Yes.
Return complaint dated 26/2/2000 received from SDR traders, Car Nicobar. Return complaint dated 26/2/2000 received from HSK Trader Enterprise Company, Parka Village, Car Nicobar. Return complaint dated 26/2/2000 received from Shmuti, son of Cyril, resident of Parka, resident of Tamalu.
Those are the two concerns from whom the money was demanded.
Yes, these three complainants, they said that this particular person,
Now, what is SDR Traders, HSK Enterprise and Timothy?
none of them were examined.
Who were they?
They are the persons who have given the complaint that I have demanded money from them. And I have seen their materials.
Specify. Who receive HSK, these three complaints are on record.
No. No, they have not even examined.
Timothy was examined.
No, Your Worship. In 2008, Timothy was
So
not
the
examined.
proprietor of SDR Traders was the proprietor. They are not exempt.
Nowhere, Your Worship, from the evidence I found that somebody has stated that he is the proprietor of HSP Traders. I will show you, Your Worship. Kindly come to page number 137. There's few things I wanted to show you, Your Worship, then I will conclude my argument.
Yes, you have finished.
Yes, Your Worship, that's only few. I will just point out the things. I will not argue.
There is a statement of Henry Samuel on 26/2/2000 on that day itself. The statement of Henry Samuel has been recorded.
But Henry Samuel was not the complainant. I am telling you, those three complainants have not been examined. I can say.
Yeah. Now, Caesar, they first kindly come to 230. Let us get hold of the story. 230 Article Charge 1, 25th February, there was a verbal complaint by Henry and Rajiv.
They were the persons who have given complaint to me, not to the authority.
Not even complaint, that was a verbal complaint written here. He came to your place with a bottle of wine or whiskey.
Yes, Your Worship.
So these two persons, Henry and Rajiv বিশ্বাস, were they examined?
Yes,
Henry and Rajiv examined.
yes. They
Very
were
good.
not the complainant against me.
But Rajiv is the proprietor of Rajiv is of
HSK Enterprises, Your Worship.
Rajiv বিশ্বাস,
Yes, Your Worship. But nowhere in the evidence it has been stated. Nowhere in the evidence. Neither in the charge sheet, nor in the evidence, no document also.
now he sealed the godown of HSK Enterprise, that is of Rajiv বিশ্বাস. But Rajiv বিশ্বাস filed a complaint to that effect allegedly on 26th February, which you are saying no such complaint was filed.
Yes.
So it was referred to in Annexure 1. Is it your contention that no complaint was filed by SDR Traders, HSK and Timothy?
Yes.
That is your contention.
No, my contention is not that. My contention is that these three persons have not been examined during the disciplinary proceedings. That is my contention.
No, these three persons neither in the preliminary inquiry nor in the second inquiry.
In the inquiry, I'm not aware, you know, that is a very old thing. In the
So,
disciplinary proceedings, they have not been examined.
No, please give us the preliminary inquiry first charge sheet issued in 2000. When was the new inquiry report was filed?
New inquiry report in 2010. 2008.
Mr. Chakraborty has given us a list of dates. Let us see.
Yes, I'm correct. 2010. 20th February 2010.
Where you are getting? 2010 na, 2001.
So that is the old one. That is quashed. By the tribunal, everything got quashed. When
Yes.
second inquiry started, the second inquiry report is 2010, 26th February
Where
2010.
do you find that second inquiry?
Report, you know, from here I'm mentioning.
22/2010.
Did you?
The inquiry was submitted by inquiry officer. After verification report, the deputy of the area dismissed the petition. 6 minutes.
Mr. Chakraborty, please give her that list of dates. Do you have a copy?
It's that from here.
Come
It's
to-
not date only I'm coming.
Come to the list of dates.
Yes, Your Worship.
Serial 3, 8th of March 2000, let us understand, 8th of March 2000 was the preliminary inquiry.
Yes, Your Worship.
Thereafter, submitted report, 6th of April was the charge issue. 6th of April was the charge. Now, what is this? 16th of August 2001, inquiry.
Report, Your Worship, which was set aside by the tribunal, affirmed by the.
That was not a preliminary inquiry, that was a regular inquiry. Three inquiries then, preliminary, this inquiry, then it, the disciplinary appeal author order, appellate authority order, challenged in a set aside. High Court affirmed that. Now after that, what happened?
Again inquiries. Again, evidence was read, parties were examined.
Just submit. Now the High Court order was passed on. You know, the OA was first order of OA was passed on. 16th August 2001. Yes. 16th August 2001 is the first regular inquiry.
First regular inquiry report.
Now the DA confirmed the proposal of punishment 21st December 2001.
Yes.
Huh?
Yes.
Now the appellate authority passed an order on 5th July 2002.
Correct.
Huh?
Yes.
Achha. Then challenging those two orders, petitioner preferred original application 37, which was allowed by an order of 16 September 2005. Inquiry report was set aside. DA and A appellate authority order set aside, matter remanded. Then agreed by the preferred writ petition, which was dismissed on 7th March 2006. Now the fresh inquiry which was conducted, it culminated in an inquiry report when
20th February 2000.
2010, page number 180.
yes, on
20th February 2010.
It's mentioned, my lord, list of dates, serial number 16.
yes, we are taking the note. 2010. Yes, you have mentioned that. Page number
188.
page number 188. Now, after that, the disciplinary authority imposed the punishment on 9th June 2010.
Yes, that was also that was also second.
No, that is the final order.
No,
No,
no.
there is a later episode. 9th June 2010 was the order of dismissal.
Yes.
Acha. Challenging the same, you preferred a statutory appeal which was allowed on 4th May 2011.
Yes, yes, ma'am.
Yes.
And it was remanded to the DA.
Yes.
Setting aside the order of DA, then subsequent day to DA passed a fresh order on 24th June
Yes.
2000. That is the final order
Page
which is
230.
page
230, my lord.
230.
page 230. Page 230. Now agreed by that, you preferred a statutory appeal dismissed on 11 July 2016.
19 July.
19th.
19 July 2016.
It is 19, not 11. Achha.
I'll just check, my lord.
What is
My
it?
lord is saying 11th, it must be 11, my lord. I'll just confirm, my lord. It was 19 July.
Yes, you are right. Yes, 19 July. Then challenging the same petitioner preferred 190,
Yes, ma'am.
which was dismissed by the order of 9th February 24.
Yes, ma'am.
Against that, this writ petition.
Yes, yes.
Yes, now what is your argument that these three persons were not examined in the second inquiry?
A few things I just want to show that those fees were required to be taken into consideration by the appellate court. What has not been done. Now, your lordship will kindly come to page number 140. This I will show the things, that's it.
Hmm. 140. Yes, 140.
पूरे घटनाक्रम में मैंने नकद रुपया लिया या नहीं?
Who is this?
संजय सिंह.
Who is he?
He is the superintendent of police under whose
Oh, he is the advice.
not to proceed with the
Raid.
raid.
Hmm.
पूरे इंक्वायरी के दौरान यह नहीं पाया गया कि एएसआई एसएम सिंह ने नकद
We are not so fluent in Hindi. Can you tell us which paragraph are you reading? Page 140?
137. In English it is translated. That's why I wanted to read it, the language is very poor.
137 is also in Hindi. Oh, right. Huh?
English.
No. Uthar. 137 to some Hindi. To.
Typed copy after that, no, Your Worship, after 141, typed copy is mentioned.
That is page 140. That's it, 140.
Typed copy is mentioned.
Yes.
Just, Your Worship, turn the page, the questions which have been asked by the delinquent, charge of that.
Yes.
Denied to cash or not in all incidents, it is not found that in the full inquiry that ASI, SNC take cash with me. Then, next question is,
Why you are showing us? That is recorded by Justice Shubha Kamal Mukherjee.
no, the second inquiry can't be recorded by Justice Sumit. Second inquiry, he was, that this entire thing happened before that.
The second inquiry report is dated, what you said?
20th February 2010. This evidence is of 2006 and 8.
20th February 2010.
Yes. And this evidence is after the judgment of the Honorable High Court.
Yes.
Why I am showing this? The reason is that these facts have not been taken into consideration by the appellate authority. That's what I wanted to say.
What is the question?
Question is whether I have taken any kind of money from anybody. He says no, it has not been
Is
found.
there any question that, have you demanded any money from anybody? Is there any question?
Other witnesses are there. I will come to.
Yes.
Question number 2. Is it fact that I have seized the go down and brought the seed supari at the police station for further inquiry? Yes, it is correct. Seizure was there.
Seizure list was prepared.
Yes, Your Worship. Seizure list was prepared. Seizure was there.
Seizure list prepared in connection with which case? There must be some case number.
No seizure list
Not
people.
aware of that, Your Worship.
No seizure list
GD
people.
was there. GD entry was there. Some GD entry was there.
No, subject to what Mr. Chakraborty says, there was no seizure list drawn up. This was
I
a
confirmed that there was no seal.
no seizure list.
It was returned, but the next day.
Yes,
Return.
yes.
Cooperative society has this is being that being government servants directly or indirectly inquired in private department or extension. About this, I have no knowledge.
I have no knowledge. Yes. That is not relevant.
That's it. Those two things I wanted to show.
Is Munir, Anandan and Selvaraj directly or indirectly involved? I have no knowledge. This is the SP saying. Yes, what else you want to show?
Next, page number 143. I have to read it in Hindi, Your Worship, because the English is not translated properly.
142.
43. क्या ASI SN से दारू पिया हुआ था? मुझे ऐसा नहीं लगा. Ananda.
Who is this Anandam?
He is also one of the persons, Your Worship, who has said that the seal has taken place in his presence.
What has taken place in his presence?
This seizure of the Supari, arraignment. And he has sealed the go down also in his presence. The evidence says he has sealed the go downs in his presence.
Hmm.
Then the question was asked whether he was in drunken condition or whether he has taken alcohol. He said, "मुझे ऐसा नहीं लगा."
Where is that?
Question
Question
number 1.
क्या इनसीन हुआ था? अच्छा,
मुझे ऐसा नहीं लगा।
मुझे ऐसा
मुझे
नहीं-
ऐसा नहीं लगा.
गोदाम आपके सामने सील हुआ? हाँ। कोई सीजर मेमो किया? नहीं। So there is no seizure list now. If there is a seizure list, then you have to take permission from the concerned magistrate to get back the article. So
Why some by conviction? Yes.
Yes, so you are wanting to, you are showing us that he was not drunk.
You know, discrepancies in the evidence. And those, I wanted to show that. I will come to that. Just, I'm showing marked one. That's it.
Oh. Okay. Where is Rajiv বিশ্বাs's?
I'll just finish it.
no, I want to know that Rajiv বিশ্বাs bought the liquor. No.
Someone,
I have found Rajiv বিশ্বাs bought the liquor.
Liquor was not brought by the.
Not right.
Rajiv Biswas.
Rajiv বিশ্বাs bought
That
the
is there somewhere we have seen.
Rajiv বিশ্বাs had given the liquor and thereafter he had taken that the police officer.
Here, show us what more you want to show.
143. Question number 1 in the cross examination. मैंने रॉबसन को क्या कागज लाने को कहा? आंसर, धंधा करने का परमिट वगैरह लेकर आने को बोला था. जो सामान ले गया था उसमें
SDR.
हाँ,
उसमें
उन्होंने SOR चिन्ह लगा दिया था ताकि रॉबसन और ए का सामान की पहचान हो सके. SOR का मतलब सुरेश ओमनिमस रॉबर्ट.
What is this?
This is the method what has been done. He has asked that bring the permit. They could not produce the permit. So the seal was.
So who was Anando? Tell us. Anando was a police inspector.
No.
He was the person in whose presence the seizure took place.
Yes.
Alex Caesar.
Yes.
And who, Robson? Who is Robson?
Yes, I'm coming to that. He is also one of the person who is dealing with all this one. One thing I wanted to clarify.
Robson's house was.
I'll come to that.
Yes.
One by one, I'll come to be clear. Now, I have been insisting upon the point that whether he was drunk or not. One statement I have shown, that statement was there in examination in chief, not in the cross examination. It was in the chief examination itself. He said, I did not feel like that. It was not in cross examination. Then, page number 145. This is of Dipankar Baru.
Examination in chief.
ये chief examination chief. क्या ASI SM सिंह शराब पिए हुए थे? मुझे ऐसा नहीं लगा.
What is the English translation of मुझे ऐसा नहीं लगा?
I did not feel like that. I did not feel like that.
Or it did not appear to him. Yes, next.
Then Pujan Prasad.
That is page.
146.
Yes.
He was the head constable.
Can we go into this? These are we are appreciating the evidence.
I am saying is something else. I am not asking for reappreciating the evidence. I am saying these were the things
We're
which
not
were
taking note of.
taken into consideration by the appellate authority.
They did not discuss.
No, that's what I'm saying. They have not discussed. Appellate authority did not touch even anything. Even disciplinary authority did not discuss these things. That's what I just wanted to show that.
Yes, yes. Then page 146.
146, 148, Your Lordship. The questions which I wanted to place. This was in chief examination. रूम में या क्या पी रहे थे? दारू का बोतल देखा था क्या? दारू का बोतल नहीं देखा था, लेकिन दारू जैसी चीज पी रहे थे। सामान जब जब्त किया तो क्या सीजर मेमो दिया था? मेरे सामने ऐसा कुछ नहीं हुआ। एएसआई एसएन सिंह ने व्यवसाय करने वाले को ये जरूर कहा था कि कागजात वगैरह लेकर सुबह थाना आ जाऊं। क्वेश्चन नंबर 5, जिन लोगों के घर की तलाशी दी गई थी या सील किया गया था, उन लोगों से क्या एएसआई सिंह ने पैसे मांगे थे? मेरे सामने ऐसा नहीं हुआ था। He was the head constable who was there along with him.
This Pujan.
Yes. Then again examination by DO. ड्यूटी के वक्त, नेक्स्ट पेज, ड्यूटी के वक्त क्या आपको लग रहा था कि एएसआई एसएन सिंह ने दारू पी थी या दारू की गंध आ रही थी? हाँ, ऐसा लग रहा था कि दारू पिया हुआ है, ऐसा मुख से गंध आ रहा है, ये ऐसे बोल रहा है पूजन प्रसाद। Inquiry officer, when he asked the re-examination, he is telling like this.
Yes.
Then, Vasanti. She was there at the time of sealing and seizure.
Who is she?
She is
Wife of somebody.
yes, wife of Anjan Roy, and she was there at that spot.
Yes.
Kindly come to cross examination 151. घटना के बाद आपने किसी को बताया कि क्या हुआ? घटना के समय एएसआई एसएन सिंह जोर जोर से चिल्ला रहे थे, बाद में सबको पता चल गया था। बाकी लोग जिनके घर में एएसआई एसएन सिंह गया था आकर मेरे पास दूसरे दिन बोले कि तुम्हारा भाई सुरेश तो घर में नहीं था, लेकिन एएसआई एसएन सिंह ने जो किया उसको थाना जाकर कंप्लेन करो। तो मैं भी मुनीर और बाकी लोगों के साथ थाना गई थी।
This was the statement of
Vasanti.
SNC is the writ petitioner. Then on whose instruction? बाद में सबको पता लग गया लोग जिनके घर जाते हैं ASI.
Somebody has told her that Suresh has told her that go and give a complaint against the SI SNC. So she has accompanied the other persons and all together they approached the police station to give her. Next now comes Rajiv Biswas. He was the person working under Henry Sampson.
Yes.
Now, all along in the examination in chief, he has said about some money demanded. Now, Your Lordship may kindly come to the cross examination.
Page
154.
Cross examination in chief.
Yes.
Had you given 2 times statement before this? What is the question? Which one you are showing?
I am showing first examination in chief, question number 2. आपने क्या शिकायत दिया था? This is important here, Your Lordship.
No. We have not gone there.
154.
Yes.
आपने क्या शिकायत दिया था? सुपारी कोबरा का जो गोदाम सील किया था हमने उसका शिकायत दिया. This is very important. The complaint was illegal seizure of Arachnet and then that copra. For that complaint was given. There was no allegation of consumption of liquor. There was no allegation of demand of money. Now, kindly come to question number 3, cross examination. आपके कहने से के हिसाब से मैं पैसे की मांग की, वह आपने खुद सुना या मनी ने आपको बताया? मुझे मनी ने बताया था, मैंने नहीं सुना। मैंने आपके कहे अनुसार पैसे की मांग किस वक्त की? मनी ने मुझे यह बात बताई थी, लेकिन मनी और ऐसे के बीच तब क्या बात हुई मैं ये नहीं जानता।
Who is money?
Just he is also one of the traders.
Yes.
Only has been examined.
Yes, anything else, Vishnu?
Yes, that's what I'm saying. I will just point out so that to establish that these were the things which were required to be at least taken into consideration.
Yes.
Discrepancies are there in the evidence. And one is saying yes, one is saying no, one is saying that he has heard, money has not been
All
accepted.
right, any other page you want to show?
Yes, yes, yes.
Receipt of.
Question number 8, page number 155.
Yes.
जब सुबह 9 बजे मुनीर आपसे मिला तो क्या बात हुई? मैंने कहा कि हम लोग थाना जाकर PSI SN से मिलते, लेकिन आपस में सलाह मशवरा कर हम लोग SP के पास सीधा जाने के लिए सहमत। So my only thing is that this was a planned thing to go to the SP and give a false report about the petition. Then Munir Ahmed. Page number 159.
If I want to, we go to mark.
159.
That page is not here. One 150.
Yes.
जब मैं सुपारी क्वेश्चन नंबर 4, जब मैं सुपारी उठाकर आपके घर से लाया तो आप मुझसे नाराज हो। हाँ, हमको लगा कि जानबूझकर तंग किया जा रहा है, इसलिए हम SP साहब के पास बात देंगे। जो सामान पुलिस ने जब्त किया था वो सामान क्या आपको वापस मिला? हाँ।
This is cross examination of Munir.
मुनीर।
Yes.
164 Henry Sender.
Yes.
मेरे खिलाफ आप क्वेश्चन नंबर 6, मेरे खिलाफ आप इस घटना के संदर्भ में किसी भी अधिकारी को लिखित या मौखिक तौर पर शिकायत दिए थे? नहीं। जिस कांस्टेबल को मैंने गोदाम सील करने को कहा, क्या आप उसका नाम बता सकते हैं? नहीं। 27/2/2000 को जब आपका गोदाम एग्जीक्यूटिव मजिस्ट्रेट और 3 ट्राइबल लीडर के सामने खोलकर ICPS द्वारा आपको दिया गया, तब आपका सभी सामान दुरुस्त और सही हालात में मिला? हाँ।
Yes.
Question number 2, 165. तारीख 25/2/2000 को जब ASI SN सिंह ने आपसे पूछा कि आपको गोदाम सील करने से आपको कोई ऐतराज तो नहीं है, क्योंकि मेरे MD ने मुझसे कहा था कि कोई दिक्कत नहीं होगा, इसलिए मैंने कहा कि मुझे कोई ऐतराज नहीं।
Yes.
Then Robson.
Page.
Page 167.
All right, you now take us to the order where it was not dealt with. That is your argument. 167.
This is the last one. 167 is the last one. Cross-examination.
What
Now,
60?
26, 167, question, cross-examination 1.
One 67, yeah.
दिनांक 26 टू 2000 को जो कंप्लेंट आपने मेरे खिलाफ दिए हैं उसे तैयार करने में कितने आदमी थे तथा उनके नाम क्या थे? ये कंप्लेंट मैंने सुरेश हेनरी मुनीम से डिस्कस करने के बाद दी।
So what does it suggest?
That it's
There was a
joint
discussion.
conspiracy, a joint conspiracy between all these people, and after that they have given a complaint against.
Yes.
Now, Your Worship may kindly come to the order of the disciplinary authority.
Or that is your argument that these discrepancies were not taken into consideration. Neither by the BL nor by the A. Anything else?
The confession, 290.
Yes. So that is quoted in the order impugned.
218.
218. In my opinion, that is not at all a confession, Your Worship. 280, Your Worship, we can-
Yes.
With due respect and with folded hands, I am to submit that I have received your memorandum dated 10th March 2010 from your good self.
That is just a page 200
18.
Yes.
Basically, with due respect and with folded hands, I am to submit that I have received your memorandum dated 10th March 2010 from your good self, whereby I have come to understand that for the findings of the inquiry officer is that the charges framed against me stood true. In this regard, I am to state that I have been facing this inquiry for last almost 11 years. I had to take shelter from reports before the various courts of law. So the entire act done by me during my tenure of posting was done in a good faith and the same may amount to procedural lapse. I am to state that as I have already suffered enough of mental as well as financial crisis, the present situation of mine has become so worse that I am begging and borrowing for running the livelihood of my family consisting of my wife and 2 sons and am innocent in all respect. I therefore request you to kindly take a lenient view of my case and sympathetic concern may also be given. I further assure that I shall be careful in discharging my duties to the utmost satisfaction of my superior authority. Where is the confession relation? This I have stated that whatever I have done, I have done in good faith. That I have stated.
Yes. Mr. Chakraborty, we are coming back after 5 minutes.
Yes.
Hey, just we are coming back 5 to 10 minutes. How long will you take, Mr. Chakraborty?
I will complete my, complete.
Only 5 minutes.
No, yes.
Lordships, prerogative.
No, we won't stop you. We here. Because you didn't complete yesterday.
Yes.
We are coming back after 2
Mine,
minutes.
mine.
Somebody over. They don't get it. I will look at that.
ঠিক আছে
the relevant complainant witnesses were not examined. Kindly have, my lord, first the evidence, the statement of Munir Ahmad, which is, my lord, the translated version is after 160. After 160, my lord will see type copy of page number 156 to 160. Now, my lord, kindly see what Munir Ahmad says, and from this, my lord, we'll know that the proprietors of the relevant complainants were actually examined, proprietors and concerned individuals. On 25th February 2000, I was going.
Mr. Chopra, just her argument was, first argument was that those three documents, no complaint was there.
No, that complaint, that is what I'm saying, my lord. HSK and SOR company, these are the two companies which are mentioned. Now, HSK, my lord, Rajiv Biswas is employee of HSK, and Rajiv Biswas's employer was also examined, my lord. He is, his evidence comes just after this, my lord, after that is Henry Samuel. So Henry Samuel is HSK. Henry Samuel and Rajiv Biswas are HSK Enterprise. And Suresh,
Yeah, just one moment. Let us, Mr. Chakraborty, she showed us page 98. This annexure 3, it contains written complaint, 3 written complaints. And her argument was that the complainants were not examined.
no, that is not correct. That is what I'm submitting, my lord.
Yes, you to the what is your?
Yes. So my lord will see written complaint of received from SOR traders, written complaint received from HSK Enterprise, and written received from Timothy. Now, kindly see, my lord, so far as HSK is concerned, both Rajiv Biswas and Henry Samuel are HSK. These are small proprietorship concerns owned by Nicobarese tribals. So, my lord, and these are proprietorship concerns. So, my lord, the two individuals representing HSK are Henry Samuel and Rajiv Biswas.
They were examined.
They were examined. Now, so far as SOR is concerned, my lord, this, my lord, is a letter, my lord. I've got only 3 PWs were not examined, and my lord, that has been explained, my lord, since it's a writ petition, my lord, and this is a government document. I don't think they'll have an objection to it being placed before the court. Now, only 3, perhaps it is part of the record also. Now, my lord, there were only 3 PWs who could not be examined. The first person was a contractor, Sebastian. And my lord, he was residing in Tamil Nadu. 12 letters were issued to him. He failed and made personal request on telephone.
This is in course of which inquiry? Preliminary or?
No, later, the final. And secondly, Christopher Calcutta, who was a driver and earlier residing, he left for mainland, has not returned to Car Nicobar. Efforts were made to find out present address. Later on, we came to know that one of the truck owners, he's residing at following address. Notice was sent, it was unserved. And third person, SOR Enterprises, Suresh Omnissus. He could not be examined since he died on 21st July 2003.
Suresh Omnissus is of HSK.
No, he is of the other one, SOR. HSK, Rajiv Biswas. Yes. So SOR, the proprietor, passed away. That is why he could not be examined.
What about Timothy?
Yes.
Timothy, my lords, according to Timothy, would have been examined, my lord, as per this letter. But that I can just find out whether Timothy was examined. We are just finding out about Timothy.
Mr. Dwivedi, do your work.
Just find out about Timothy. Now, kindly see, my lord, what Munir Ahmad says. Munir Ahmad says, page 160, translated copy after page 160. On 25th February 2000.
Just page. Munir Ahmed is at page.
It a translated copy is page after page 160.
164.
No, after page 160. If my lord has 160, the Hindi ends at 160. The next page says type copy of page 156 to 160. That is Munir Ahmad. Now kindly see, my lord, what he says.
I have not got it. Just.
So, my lord, after once, my lord has 160.
I have got 159.
So kindly go to 160 after that.
No, no, 159, she drew our attention to.
I'm coming to that. I'm only reading the
Now
transcript.
you are showing us page 160.
After 160,
After 160.
that says type copy of page numbers. My instructions that Timothy was also examined. We'll just try to find out the page number. Page 150, ask him to give the copy of the deposition. 150, kindly see that statement of Shri Munir Ahmad,
Yes. Munir Ahmed.
son of Abdul Malik. Now kindly see, on 25th February 2000, I was going to Malakka Masjid for Zuma. My meeting has been occurred with ASI SN Singh in the way near Tamanu village. ASI SN Singh asked me that due to business of beetle nut, I replied yes for that, and also told that it is known by you too. Then I had left from there. After that, on 26th February 2000, at about 2:30 a.m. morning, a sound has come on the door of my house for opening the door fastly. On opening the door, I saw that ASI SN Singh was standing in front of the door, and police staff was also with him, about 4 to 5. One Omni and one truck of one Mr. Sebastian was also with them. I saw the police was searching something surrounding my house. I asked what had happened. ASI SN Singh told that give money, otherwise seize the beetle nut. Then I said that you have any search warrant or any order of any senior officer. Then ASI Singh told that order has come from higher, and if you want to see the order, come tomorrow at police station and have seen. Again, SN Singh told that if tell more much, I will take you to police station. ASI SN Singh was under influence of alcohol. So I have understand to talk much more much. After this, ASI SN Singh took 8 bags of beetle nut from veranda to keep in truck and have gone. After this, I went to the godown of Rajiv Biswas, HSK, and Suresh Eswar, who died before tsunami, and met them. It is brought to notice that ASI SN Singh had also sealed their godowns, which was seen by me. Then I asked that what are you people thinking? On this, they told that he has called us to police station at 9 o'clock morning, so we'll go to police station. On this, I told that first of all, we should meet to SP Sahib, because it is known to us that ASI SN Singh has done this work under knowledge of SP Sahib or not. In the morning, we all reached to house of SP Sahib. SP said to come in office. Then we all went to SP's office. SP Sahib has also come to the office, and we told our matter. SP has become very angry on ASI SN Singh and said to us for giving written complaint. After this, SP has talked to DC office over phone and also called the members of tribal council. Then SP has done the inquiry himself and recorded statement of all witnesses. The work was continued from 26 February 2000 to 27 February 2000 at 3 o'clock morning. After this, a big vehicle has brought to police station from EHL, and we all have brought to the police station. It was told to us for identify our supari bags. After that, we all went to the godown of HSK and SWR as well as my house. SP Sahib also come with us to return the goods. For doing these, it has become at 4:30 a.m. morning. SP Sahib said, if any problem occurred with you, then inform me. Now, kindly see the examination in chief. On 26 February 2000 at morning 2:30 a.m. when ASI Singh came to our house, then how many money asked? 20 rupees 20,000. On 26 February 2000, when police has brought the supari back from your house, then any written certificate or seizure memo was given? No. ASI SN Singh said that if you want to see seizure memo, come to police station at morning and see. This is the upper order. Cross examination. Do you have any written complaint against me? Kindly see after that. No, Timothy had given written complaint. I had given only statement. Because now this is very important, madam. Because incident had occurred at my house and Timothy lived in my house with me. So Timothy is lived with him.
Relation of Munir.
Nicobar tribe. So Timothy lives with him. So Timothy, and he lives in his house only. Now, as per your statement, then when I demanded money, then was I alone? No, ASI SN Singh was stand in the veranda and other people were stand in Anangan at the distance of 7 or 8 feet. How can you say that I was drunken liquor? Behavior of ASI SN Singh was just like a drunken man, and ASI SN Singh just rolling like drunken man. And on 26 February 2000, ASI SN Singh expected himself before SP. Then he has drunken liquor along with Henry and Rajiv Biswas while they have dinner. When I brought the supari from your house, then you became angry. Yes, it was feel by me that by fully knowing I'm harassing by you with full preparing. Now kindly, therefore, out of the three people, both the HSK Enterprise is represented by Rajiv Biswas and Henry Samuel, whose evidence your lordship will find after 165. Kindly have after 165. And Timothy is represented by this gentleman, Munir Ahmed. So Timothy, out of the three, the two who were alive have been examined. The third was dead, my lord, so he couldn't have been examined. So Henry Samuel, kindly see what Henry Samuel says. On 25th February,
SOR could not be done.
SOR was dead, therefore he could not be done. Timothy, Suresh was
Showing us that was
SOR.
with SOR.
SOR. So he was dead, so he couldn't be examined.
And Timothy.
Timothy is Munir Ahmed. Timothy gave the written complaint, but Timothy actually lives with Munir Ahmed in his house.
Timothy's statement is
Because Munir Ahmed was the business person. Timothy was living with him in his house. So she's a tribal lady, so she had given the written complaint, but it is the one and the same. Timothy and Munir Ahmed are one and the
sought
same.
to be corroborated by Munir.
Yes, correct, absolutely.
So Timothy's complaint was not there.
Timothy,
It was the statement of Munir.
Yes, that is correct.
Yes.
Correct.
Next.
Now, after that, my lord will see, so far as HSK Enterprise is concerned, first is Henry Samuel, which is at after 165. On 25th February 2000, in fact, even one complaint is sufficient, my lord. There is no requirement to have 3 complaints, so far as this misconduct is concerned. On 25th February 2000, my lord has
165.
After that, my lord, typed copy begins after, translated copy after that. On 25th February 2000 in the evening, I was in my house, which was in Perka village. My house and godown were get together. I always kept purchase copra and supari in the godown for business.
No, you need not go to the entire. Your argument is Henry and Rajiv both had deposed
For HSK.
So HSK is over. So what is SOR?
Yes, he was dead.
In spite of best efforts could not be made.
Because he was dead.
He was dead. And
was
this
dead.
Mr. Sebastian.
Yes.
Sebastian. Who is this Sebastian?
So these are all
Sebastian is not, we are not. He has pointed out these 3. Very good.
And Munir Ahmed is Timothy. And Munir Ahmed is corroborating Timothy's complaint because.
Yes.
Now, so this is the first part. Now, secondly, so far as the my lord, another query which had my lord fallen from the bench yesterday. Another query my lord had in fact yesterday posed this query that was there seizure list, and otherwise second part was that what happened to the goods. So my lord, the articles of charge, my lord, they themselves record. And that firstly, my lord, that there was no seizure list because the seizure was done without observing any legal procedure. If my lord has the memorandum of charge, this is at page 96. Yes, kindly see page 96. I've got a better copy. In fact, if my lord would like to see, I have a better copy. I'm just handing that over.
No.
Manoj, you did. But this is part of the record, page 96. Kindly see,
Just.
my lord.
Yes, 96.
96, my lord, that better copy I've given. Kindly see the last paragraph. Last line of the first paragraph. ASI Sheshnath Singh then went to the residence of one Munir Ahmed and demanded 20,000, and on refusal to give, he seized 8 filled bags of supari belonging to Munir Ahmed, which was kept in veranda in the house without observing any legal procedure. So the specific allegation is that so he did not follow the legal procedure, which would, as had fallen from my lord, that my lord, a seizure had to be carried out after taking the order from the magistrate. Now, therefore, firstly, there was no seizure, and they are not the defense has not been able to establish otherwise in the course of the departmental proceedings that there was a seizure list drawn out or permission was sought from the in accordance with law. Now, so far as
How does that help you? It goes against you.
no, he was required to take permission if he had to actually carry
No,
out.
he has not ceased by preparing a seizure.
Yes, yes.
Now, in the backdrop of that, the contrary argument is that there was a seizure without a seizure list, but the
Yes.
same was returned, and the complainant was satisfied with that.
No, point is
His, if we,
My lord.
one thing, please clarify,
My
this
lord.
allegation of 20,000 and 50,000, this
Hmm.
fact subject to what you submit is not directly on record that this money was taken by him. There is no evidence.
That is not the case, my lord. The case is different here, my lord. This is a case of misconduct. It is not a case of
No, first,
no, I will read from
charges. Peremptorily, it is you have defied the order of the estate.
first defied the order. Second,
Second, you
for illegal gratification.
are lacking integrity and
Yes, yes,
since
yes.
you are drunkard. And third is since you have taken money,
Not taken
illegal gratification.
demand for illegal gratification. It is not that disciplinary authority has dealt with this argument. I'll go to the disciplinary.
Kindly come to the in which you are reading. ASI Sheshnath then went to the residence of Muni and demanded Rupizato as
Yes.
illegal gratification, and on refusal to give such illegal gratification, he sees. So there is no allegation that he has actually taken the money.
Yes, yes.
But there was a demand.
Demand. And my lord, now what happens to the goods? Kindly see the next page. Page number 97. Last paragraph. Because of the intervention of the superiors, now what happens is the
Page 97.
Yes, my lord. And the clear copy is there, my lord. I've given the clear copy, second page. Bottom of the page.
Yes.
The seized goods supari which were brought to police station Car Nicobar and the sealed godowns were subsequently handed over to the rightful owners on 27th February 2000 as no cognizable offence was made out. Now see, it is thus clear that ASI Sheshnath Singh, who was drunk, deliberately disobeyed the reasonable and lawful directions of a superior officer and initiated action on verbal complaint and sealed the godowns and seized goods without observing legal procedure relating to sealing, search and seizure, etc., with an ulterior motive to harass the businessman and extort money. His such actions speak of grave misconduct, breach of trust, abuse of official position, and deliberate disobedience in abuse of his official and on his part in contravention of mandatory provisions on the Rule 8.45 and Rule 8.47 of ANN Police Manual, thereby unbecoming of a police officer and rendering him liable for punishment. Now, kindly see, my lord, what the disciplinary authority says, my lord. The disciplinary authority,
Page 296.
my lord, 230. Kindly see, my lord, the order of the disciplinary authority. Page 230, my lord, it begins, and as has fallen from your left. All the contentions, my lords, the evidence has been elaborately discussed, my lord. We'll see the order. It's seldom that such a well-reasoned order is passed by a administrative authority. Kindly see, my lord.
So you admit
Page
that on many
233.
occasions they do not file proper order.
Maybe one of the cases.
Kindly see, my lord, 233. 233, bottom of the page, on perusal of the article of charges framed against the delinquent officer, mainly the following acts of misconduct alleged to have been committed by him. First, the delinquent officer had deliberately disobeyed the lawful instructions of the senior officer of the rank of superintendent of police. Second, the delinquent officer in a drunken condition had performed duties. He acted on his own accord, sealed the godowns and seized the bags filled with betel nuts of Eswat traders and Munir Ahmed. So the Timothy had written the complaint, but the nuts belonged to Munir Ahmed, without observing legal procedure with an ulterior motive for personal gain. 3. The delinquent officer Sheshnath Singh had demanded illegal gratification from traders. Now the above acts of misconduct committed by the delinquent officer are examined and evaluated as under. In respect of the misconduct of the delinquent officer mentioned above.
No, you placed that paragraph. I have informed SP. Yesterday you.
Yes, yes, sir. Yes.
And construed it to be and said that this is an no, sorry. He has done in good faith, he said.
Yes, no. Import to this. Now kindly see inquiry officer, I'm reading after that, my lord. Inquiry officer in his report has held that ASI Sheshnath Singh was clearly directed by the superintendent of police not to take any action and to produce complainants before him in the morning. Rather, it was a general complaint, did not disclose any urgency. In fact, Sheshnath Singh had not accepted the verbal direction given to him over phone. It is therefore clear that Sheshnath Singh took action deliberately with an ulterior motive, did not follow legal procedure as per law, and also disobeyed instructions of his senior. The delinquent officer in his defense brief, dated such and such, never took the plea in his support with regard to misconduct. He himself accepted that he had defied the orders. Further, from the above, it is clear and unambiguous that the delinquent officer had defied the lawful instruction of the senior officer of the rank of superintendent of police, and therefore his misconduct had been proved beyond reasonable doubt. Now coming to the second misconduct of delinquent officer, in that he was in drunken condition. And he took the action, acted on his own account, sealed the godowns and seized the bags filled with betel nuts.
Where you are reading?
Page 235, ma'am. Second part.
235.
Yes, ma'am.
Yes.
Now coming to the second misconduct of the delinquent officer, that he was in drunken condition when he took the action, acted on his own accord, sealed the godowns and seized the bags filled with betel nuts of Eswat traders and one Munir Ahmed without observing the legal procedure with an ulterior motive for his personal gain. In this regard, the relevant portion of the statement differs by H.C. Pujan Prasad is reproduced below. Then my lord Pujan Prasad says that at such and such took the tiffin with meals for Shahab to his quarter. At that time, Shri Rajiv and Shri Henry were present in the room. They and Shahab were drinking, which appeared to be liquor. Thereafter, I went to barrack and slept. At about 11 to 11:30 p.m., the sentry had woken up and informed me that Shahab had called me. On reaching there, I found many staff were present. I came to know that a raid was to be conducted. I, along with Shahab, Shri Henry, Rajiv and other staff boarded the Omni and private truck and reached Rajiv's house. Sahab opened the godown, and after inspection, godown was sealed. Thereafter, we went to Anand's godown and sealed his godown. After that, we went to Munir's house, and Sahab asked him to show the permit of doing copra and betel nut business and seized the 5 to 6 supari bags and loaded into truck. During examination in chief of PW6 on the question whether any seizure memo was prepared while seizing the goods, the witness stated, in my presence, no seizure memo was prepared and simply directed them to come to police station next day morning with documents. During examination of PW6 by inquiry officer as to whether he had felt the ASI Sheshnath Singh had consumed liquor and whether smell of liquor was coming out from his mouth, the witness said yes. From the smell coming out from mouth of ASI Sheshnath Singh, I felt that he had consumed the liquor. Relevant portion of statement of Henry Samuel. Rajiv told me that ASI Sheshnath Singh was waiting for us. I, along with Rajiv, went to police station in scooter, and from there we went to residential quarter of Sheshnath Singh. Rajiv Bishwas was holding one bottle of liquor with him. All of us, including ASI Sheshnath Singh, started consuming liquor. ASI Sheshnath Singh called.
Rajiv has deposed. No?
Yes. Rajiv has also deposed. Henry, his boss, has also deposed.
Can you show us Rajiv's deposit?
Yes, my lord.
Another thing is that I can forget. They have taken into consideration the evidence of the PW6 that he consumed liquor.
Yes.
And Rajiv Biswas's deposition that he consumed liquor.
Yes, ma'am.
But this inquiring officer or whatever it may be, he did not consider the deposition of S. Anandan and Deepankar Borai, where those witnesses have told that मुझे ऐसा नहीं लगा वो पिया है कि नहीं है. Why this?
It is considered, my lord. On the next page, it is up. If my lord sees further,
Okay.
everything is considered. My lord.
We'll come to Rajiv.
Rajiv Bishwas, my lord, will see.
Although you find it out, you proceed what you are saying.
Is page number 156, 155. After 155, Rajiv Bishwas's evidence.
The matter was at the in the night 2 a.m. I think. It's talking 2 a.m. And SP also went to the spot in the 4 a.m. of that. So why at that time why the SP did not take examination of his subordinate that whether he consumed liquor or not? So very within 2 hours, it can be detected. But I want to,
I have to ask, find out, my lord.
no, you see, if the SP came to know that his subordinate had had consumed liquor, why immediately that test has
My
not
lord,
been
I
done?
can only say, my lord, this is,
No, no, I want
since it is a departmental proceeding, my lord, the test is not like that of a criminal, my lord, prosecution. It is only on preponderance of possibility, my lord. Misconduct is sufficient.
Mr. Chakraborty, Supreme Court, I'm just, the judgment has not been placed. Supreme Court says when it is a civil consequences and the ultimate punishment of dismissal, the test of preponderance of probability stands converted to a test as to whether the offence has been committed to its hilt beyond reasonable doubt.
My lord, according to me, my lord, there is sufficient evidence in this case, my lord. It is not a case.
It is not a case of no evidence.
Yes, ma'am.
And no perversity.
Yes.
So when there is no evidence, if there has been no evidence, proceeding ought to have been quashed. But it is not a case of there is a plethora of pieces of
Yes,
documents which show that the direct involvement and the misdeed which has been committed pertains to the integrity and discipline.
And my lord, I'll just place the judgment, my lord. Supreme Court has recently said, my lord, that even if there is the report of the inquiry officer is detailed, my lord, there is no requirement even to record detailed reasons by the disciplinary authority and appellate authority.
That has been said in the judgment which she has placed.
Yes, my lord. I am also carrying those judgments.
Those are a brief reason given will suffice.
Yes, and my lord, here, my lord, firstly, my lord,
Your contention is that there is you have not seen the whereas clauses incorporated in the
No, I am assuming that against my client. Kindly first see that inquiry report is at from 188 to 217. That contains detailed, my lord, the conclusions in the inquiry report 188 to it begins at 188.
Very good. That is, we need not go through the entirety of it because it is your contention that there has been a detailed inquiry and it is not a case of no evidence.
Yes, so 188 to 217 detailed inquiry report. Page 230 is a very, very detailed, my lord, disciplinary authorities order. And then their contention is appellate authority's order is cryptic. Now the
Disciplinary authority is page 230.
Now kindly see, my lord. In fact, there are cases where, my lord, I'll just place those. I just wanted to place two judgments, my lord. First, my lord, this 2021 judgment. There's 3 judges, my lord. Kindly have. Kindly have para 11. This is in fact, here it is. Para 11, my lord, may have what the Supreme Court has said in 2021 3 SCC.
Yes.
Page 810, page 5 of the printed. We are of the view that judgment of this court in ECIL is not helpful to the case of the appellant. Further, it is very settled that if the disciplinary authority accepts the findings recorded by the inquiry officer and passes an order, no detailed reasons are required to be recorded in the order imposing punishment. The punishment is imposed based on findings recorded in the inquiry report. As such, no further elaborate reasons are required to be given by the disciplinary authority. So, in this case, there is a detailed order passed by the disciplinary authority. They have done a much better job than was required in terms of this judgment. Secondly, my lord, recently, my lord, the Supreme Court has dealt with this issue, my lord, 2025 judgment.
Volume.
I am giving the copy. 2025 SCC Online SC 232. Now, kindly have, my lord, paragraph 32. This law is reiterated. This 2021 decision, my lord, which I had just cited, has been reiterated. But, my lord, the court also. 32, my lord, page 12 of the SCC Online. It is straight law that in disciplinary proceedings, it is not necessary for the disciplinary authority to deal with each and every ground raised by the delinquent officer in the representation against the proposed penalty, and detailed reasons are not required to be recorded in the order imposing punishment if he accepts the findings recorded by the inquiry officer. Then kindly see after that, para 33, all that is required, this I had already read from that earlier judgment, all that is required on the part of the disciplinary authority is that it should examine the evidence in disciplinary proceedings and arrive at a reasoned conclusion that the material placed on record during the course of inquiry establishes the guilt of the delinquent employee on the principle of preponderance of probabilities. This is precisely what was done by disciplinary authority and appellate authority while dealing with the case of the respondent. Now, in this light, page 230 onwards, my lords, is the detailed decision of the disciplinary authority. And the appellate authority, in fact, in this case, the inquiry report is detailed, the disciplinary authority's order is detailed. At the highest, if the case is to be accepted, the decision of the appellate authority is not reasoned, does not contain detailed reasons. Now, the appellate authority has affirmed the decision of the disciplinary authority. So, the order of the reasons given in the order of the disciplinary authority merges with the decision of the appellate authority. And if the Supreme Court says that the disciplinary authority does not have to give detailed reasons and can affirm what is stated in the inquiry report, certainly, my lord, the appellate authority is well within its powers, my lords, to affirm what is held by the disciplinary authority, and the reasons which are given in the inquiry report and in the order of the disciplinary authority will merge with the order of the appellate authority. Now, kindly see the decision of only the ground which they have raised is, my lord,
Page.
260 is the decision of the appellate authority. 262 it begins. And all after the factual narration, kindly see page 265. Second recital onwards. Whereas Dr. A.K. Singh, IPS Superintendent of Police, Car Nicobar, was appointed as inquiring authority with an order dated 9 July 2007 to inquire the charges leveled against him. The inquiry officer.
This is the third inquiry.
Yes, yes.
Preliminary, first inquiry, second inquiry.
Yes, yes. The inquiry officer completed the inquiry and submitted his findings afresh on 20th February 2010, holding that charges framed against ASI Shishnath Singh have been proved. Whereas the disciplinary authority, after perusing inquiry report submitted by inquiry officer, written reply submitted by the appellant, and after giving an opportunity of personal hearing on 23rd April 2010, disciplinary authority has dismissed the appellant from ANN police force, holding that he is unfit to retain his service. Whereas the appellant has preferred an appeal before appellate authority against the said order of dismissal from service passed by the disciplinary authority. Appellate authority disposed of the appeal by internally observing that order passed by disciplinary authority is not a speaking reason one and remitted the matter back to the disciplinary authority. Then next page, whereas in view of order dated 4th May 2011 passed by appellate authority, appellant was again placed under continued suspension with effect from date of his dismissal. In pursuance of order dated 4th May 2011 passed by appellate authority, disciplinary authority have re-examined the entire disciplinary proceedings and record points raised by the appellant in his defense brief and his written reply dated 30th March 2010 and passed order of dismissal. Whereas the appellant has preferred the instant appeal, I have gone through the records of the case and contentions put forth by the appellant. Based on the same, the undersigned does not find denial of opportunity, reasonable opportunity for defense during process of the inquiry, departmental inquiry conducted against Shri Sheshnath Singh, Assistant Sub-Inspector. Also, there is no merit in the contention of the appellant. The order passed by disciplinary authority is not in conformity with facts and law. So, the appellate authority has affirmed the decision of the disciplinary authority and the inquiry officer. So, in terms of the Supreme Court judgment, the appellate authority only further reasoning is not required, and the same if the order is good, it will the reasons have to hold good in any judicial review. And the Central Administrative Tribunal, my lord, has passed a detailed judgment, my lord, which your lordship will find at page 416, which is the order impugned before your lordships, where, my lord, the Central Administrative Tribunal has painstakingly, my lord, exercised the power of judicial review and has gone into the facts and merits and has been arrived at its conclusion, my lord, that there is nothing wrong with the order passed by the appellate by the authorities below. So, my lord, this is the second stage of judicial review before lordships. It is not that it is not as if the decision of the disciplinary authority has not withstood legal scrutiny before. the decision has, let us assume that the appellate authority has merely affirmed the decision. But what has withstood judicial scrutiny before the Central Administrative Tribunal already is now challenged before Lordship. So, my lord, your lordships are exercising, it is like a second appeal, my lord, in that sense. So, therefore, my lord, the
We cannot go into the
Yes.
evidence at all.
the tribunal has also considered everything. And my lord, this person, my lord, although it is not strictly relevant, but my lord will see in my note, my lord, as a matter of it is as a duty to the court to make a fair disclosure. There are two other proceedings pending against him. One from my lord.
That is not on record, Mr. Chok.
This is a restricted tribal area. 59 bottles of
No,
Indian.
this is not within the purview of this.
That is true. Man.
That we cannot, even if you mention, we cannot
Yes, yes.
affirm that. This is your argument. Yes, thank you. No, where is the, can you show us the, what is, you said 9.7 penalty?
9.3.
9.3.
9.8. 9.23 is the appellate authorities. What appellate
Not to there
authorities
already.
do?
There, yeah.
9.3 of police file.
এই দাও একটু পুলিশম্যান বলতে এই যে আরেকটা মোটা হচ্ছিল মালিকানা না না বইটা পুলিশ ম্যানুয়াল
Police file 9.3.
नहीं दिखाना है पता
Chapter 9 deals with punishment and appeal. Chapter 9 of the police.
chapter 9.
9.
Yes, anything in reply you want to say?
Yes, yes, chapter 9.23 I just want.
9.2. Which page? 9.
9.23, page number 72.
Nine point three I have got.
9.23. Page number 72.
Just to read it.
72. 9.23.
In the case of an appeal against an order.
9.23.
No,
Oh, acha. Yes.
In the case of an appeal against an order imposing any of the penalties specified in Rule 9.1, the appellate authority shall consider A, whether the procedure prescribed in these rules has been complied with, and if not, whether such compliance has resulted in failure of justice. That is
That's non-conforming.
no issue. Whether the findings are justified and whether the penalty imposed is excessive, adequate, inadequate, and past offense. These are the things which are A, I am accepting. He has considered A. B, C, where is it? It is provided in the manual itself.
So sentencing.
Yes, sentencing and findings. Whether findings are justified or not, for that he has to consider the evidence. Without considering the evidence, he can't say findings are justified. It is provided.
When the evidence has been affirmed, when the evidence has been affirmed by the disciplinary authority, appellate authority, you are right, it has the right to go to the evidence. But Supreme Court has said that it is not a question of reappreciation when you find a detailed clarification is given. Suppose you make a submission, I can deal with it in 5 pages, I can deal with it in a 1 paragraph.
It has to be dealt with.
Yes, that has been dealt with because the illegalities was perpetrated. That was the sum and substance of the inquiry report, the disciplinary authority report. So the findings which have obtained affirmation by the disciplinary authority, if I do not agree to it, then I have to give these detailed reasons. But if I accept that, madam, then in that case, subject to what you are submitting,
Decisions which I have shown you, the Honorable Supreme
that,
Court.
that decision itself says that at least some small reasoning should be there. That is the wording.
I am saying, Your Worship, there is no reasoning at all. That's all.
That is your
This
argument.
is complied with, there is no requirement to look into it. That is what is the order passed by the.
That is your argument. That is your argument.
That last paragraph states so, Your Worship, in the appellate authority's order.
Yes.
Your Worship, the only thing which I wanted to submit, the discrepancies in the evidence, which I
That
projected,
was not taken note of.
neither by the disciplinary authority nor by the other.
No, you have, your argument, if you have understood appellate authority order reasoning, defects, the discrepancies were not taken into consideration. And
9.23, Your Worship, the two B and C has not been considered. Appellate authority was required to look into it, as per the manual.
very good. Yes, the learned advocates appearing for the respective parties have concluded their arguments. Stop. Judgment reserved.
Obliged.
Ajay, Mr. Chakraborty, do you want to, I don't know, she must have was, in the interim stage, any sort of opinion or
No,
observation made in any of the orders? Because there is a big bundle of orders.
no. There is no interim order.
No interim order refusal or allowing was
No.
there.
There is no interim order.
Only there was some direction of supplementary paper then that I have already submitted before. I am not interested to file the supplementary paper. That is finished.
There is no interim order.
Yes, nothing.
Thank you. Thank you. No. এটা নিয়ে নাও। দেখুন বাকি। হুম। Yes, next. Also those. Yes,
Item 6 already fixed. Item 7, committee 7 to 6 of 2024 with item number 8, committee 1 of 2025.
what is this matter?
That labor related matter, Mr. Rakesh is there, paper books direction. Ready, my lord. So Rakesh asked me to file it before, my lord, your lordship.
তার জন্যই রেকর্ড করবো। Mr. Kumar Learned Advocate appearing for the appellants. You are for whom?
I am appearing in
এই শোনো মনোজ, আমরা উঠে নাই দুটোর সময় আসছি, দেখতে পৌনে দুটোর সময়। Yes, which is your matter?
Sir, item number 11 is the matter, it speaks for filing report today. And we have already filed the report.
report দিয়ে আসবে।
This is an appeal matter that is going on, matter slow motor public interest litigation.
To go in the next.
Yes, yes, my lord, only records that we have filed the report and a copy has been circulated.
ডাকো একটা item number 9,
Item 9, WPA.
next item 10, next ডাকো 10,
Item 10, WPC 234 of 2019.
next
Item 11, WPA 3 of 2022.
to fight other. Tell us what was directed, Mr. Shan.
My lord, if the circuit, my lord, we filed a progress report. It is about the National Highway 4, where my lord, Mr. Kumar and Mr. Kabir happens to be my lord special officers.
Oh,
And my lord, we filed a status report on behalf of the NHIDCL. We demonstrate before your lordship the progress of the work. At the initial stage, there was very poor progress we admit, but subsequently, my lord,
Mr. Shanna learned advocate appearing for NHIDCL. Files the report as called for by an earlier order of this court. Stop, let the same be kept on record. Stop. Copies of the same have been handed over to the
yes,
learned
only I will
advocates.
submit one, Mr. Lal.
Learned advocates appearing for the respective parties to court today. You are the special handed over to the learned advocates appearing for the respective parties and also to the learned special officers in court today. Now, any sort of urgency is that we have to take it up. It is going on. It is going on. But we are told subject to correction. This is the road from Baratang to
From Port Blair Road, Lamia Bay. Including.
Lamia Bay is Digli. Now, the part of the road we are told that is still in a treacherous condition.
Yes, my lord, what happened, my lord, there were certain administrative difficulties also faced by us that my lord special officers has taken care of. There has been a meeting which I was told to the secretary. And my lord, these date blocks are my lord being worked into and the.
So what do you expect when it will be complete?
We have filed a report, my lord.
What does that say? That any development?
It will take some time. The entirety of the project will not be complete before 2026. But the issues where the problems are, that has been addressed and my lord, if you lordship finds out in the last report also we have stated. And my lord special officers have also filed a report. Wherein we have indicated that the problematic stretches that has been addressed so that in the rainy season that there is no problem.
Court said it will be done within 4 weeks.
My lord, that is one stage probably.
There are plenty of directions in the earlier order.
Yes, yes, there are. My lord, is looking at the March order. My lord.
Now, where is that order towards filing of every report, Simon, for after a particular period, repeated reports are.
Yes, circuit report, yeah, yes. In each circuit, we have to file one report. Now, what happened?
Where is that order?
That is long back. That is in 2023.
Or when we are keeping it on the reopening date of the shall come with the next development.
Yes, yes, yes. 1 week after vacation. Another 1 week after vacation, because we will also have to ascertain because there will be a long gap.
तो ऐसे लिखे हैं कॉपी list the matter for further consideration. List the matter for further consideration on 16th June, subject to the convenience of the honorable court. Stuff. A further report shall be filed by NHIDC on the returnable date.
In post mallet, we'll also mallet administration and mallet the NHIDCL will mallet reimburse the learner special officers mallet.
Yes.
That will.
But when you are
In
reimbursing,
course of the week, mallet, in 1 week we do that. But there was year-ending problems and all. Mallet, in 1 week we do that. There is a direction also. We do that.
that period has gone.
No, there is no time period for payment. This only said that you will going to reimburse. There is no time period.
No. It's also to see.
Mr. Khanna, have you,
We'll be happy, my lord. My lord may direct, it will be easier for us, my lord. My lord may say within 1 week.
are you saying what is the remaining amount to the special officer?
Mallet, every bench mallet, there are every bench.
1 lakh to each officer, 50%. 50 by.
So you have not paid that.
Yes, that previously it was paid. After a long gap, mallet, the last honorable bench mallet.
So you ensure that before 16th another amount is.
Absolutely.
Yes, my lord.
Ensured. That is our duty mallet to put in.
Yes, absolutely.
Next.
Yes.
Item 12.
Fact A. First appeal.
For the respondent, other side for an application under 41/27.
That will be heard along with the appeal.
I will file objection in the meantime.
The paper books we did it.
Because it's already, but he is to prepare supplementary the review of this. Want to rely on.
Who is for the appellant? The file to dog. Mr. K. Vijay Kumar. He was just now here. No? কোথায় অ্যাপ্লিকেশনটা কোথায়? Records reveal that in connection with the appeal, an application under order 41 rule 27 বাকি দেখে দাও।
Item 13, we are doing. Item process.
My appeal. There are two appeals.
The first one is filed by the state.
Mr. Kobi, go before the next one. It's not possible. We have 2 more working days. We have reserved judgments. It may not be possible for us. Any paper books and everything have been filed.
Section 5, allowed lordship, especially also grant.
Granted.
Okay. So that what the stage of admission, everything is ready, appeal is ready to go.
Both the appeals are ready for.
They are connected out of the same judgment. One is filed by the victim, one is filed by the state.
কি করে শেষ করব? দুদিনে তো শেষও হবে। Next circuit. Next circuit it will. Yes, call them.
Mentioning in the list, item number of WPA 187 of 2025.
My lord, this matter I am appearing for the writ petitioner, my lord, and in acquiesce where for the same reason I had approached my lord. On the basis of the complaint of the writ petitioner, a revenue case was initiated by the Tahsildar Fort Blair Tahsil, and Fort Blair Tahsil had passed the stay order. It appears at page number 16. I pray that my lord within a time.
You are the petitioner.
Yes, I am the writ petitioner. I have made a complaint before the Tahsildar.
So very good. Against whom?
Against the respond number 3 and 4.
So have you served them?
Yes. I had filed the affidavit of service also.
Now have you checked up? It has come back.
Yes, my lord. It is delivered, my lord.
Delivered.
Yes.
Then,
So, my lord, on the complaint filed by me, page number 16, my lord. Revenue case was initiated and a stay order was passed against the private respondent, but no date has been given for further hearing. I pray that Tahsildar may. Yes.
it has gone in your favor. What is your problem?
My lord, but no date has been given. Still, it is pending, my lord. I pray that it may be disposed of within a time frame manner.
Stop the construction work
But
till,
till further order.
2025.
So this was passed on 14th February 25.
Yes.
We are in April.
Yes, my lord, but no, the revenue case is not being disposed of till date, and no notices were served. I pray that the revenue case may be disposed of. Only that innocuous prayer in the time bound manner.
Show it to him. One person has not received their say.
My lord,
Who has not received?
respond number 4, I suppose it is written as addressee left without instruction. Respond number 4.
Every service, as file, be kept on record. Mr.
Lokesh Chelier.
Learned advocate appearing for the petitioner submits.
in a part of my land.
Oh,
But now they are contemplating to take rest portion of my land, for which I have come up with this writ petition.
so you didn't complain against the poll?
I have, Lordship, I'm contemplating to file a civil suit because poll has come in, Lordship, I have to file a civil suit seeking
Yes.
eviction. But so far as my west part of my recorded property is concerned, look, every now and then the revenue officials in active connivance of the BSNL enter into my property. A threat of dispossession is being administered, Lordship. If they want my property, take it. In accordance with the, take it, acquire it, take the property, pay me the compensation. But in not this way, Lordship. So complaining this it has been taken off, Lord.
What is this page 20?
Page 20 is my an application to the Tahsildar because under the local regulation, my lord would see that if I am holding a property, I have a right of improvement. No permission is required. Not this position of law, my lord, sitting with his Lordship Honorable Justice Ashwin Kumar Banerjee has passed an order.
So what are you praying for?
No, I pay Lordship, my property should not be taken the way they are trying to do. You take.
So where is this anticipation?
Lordship, I have
So,
without due
This
process.
order is, we have erected the mobile tower in our land, which has been allotted by the Deputy Commissioner 98/2, which is not recorded in this. So boundary dispute between two parties.
another person is?
BSNL and myself.
And the writ petitioner.
So Mr. Jaipal.
No, let me take, because
We are not interested.
tower part have cleared. Already they have taken.
No, we will record that. Your anticipation is misconceived at
No,
this.
page 21 mechanism is in once. Page 21 mechanism is in once. At my behest, this order was passed. Thereby, Lord would see the paragraph 1. A revenue case number so and so has been initiated for the boundary dispute between government revenue land and the recorded land of Srimati Sugandhi. It's a writ petition.
So very good. We will dispose the Tahsildar to dispose of that revenue.
Yes, ma'am.
This 265 TM.
Passing number, yes, ma'am.
365.
This has to be,
Page
a
20.
logical conclusion has to be arrived at.
Can be disposed. But it's maybe recorded in Lordship that land has been allotted to us 98/2, 0.02 hectares.
And what is his land, Mr. Jaipal?
It's at page
You are in?
Page 18, 99/1, 99/1P, 99/2P.
Mr. Jaipal, and evidence service from as file be kept on structure this order which has been passed in January 2024. You are coming after 3 months, showing a stay order pertaining to a complaint which was initially lodged and order was passed. Now that has merged in the final order, or rather the order at page 22. Now what relief you want from us?
My boundary are, Lord, my prayer is, I'm having an apprehension as to that my property would be utilized by the BSNL.
You have to be a clean person. You will still be obligated.
Without due process for not.
If it is so, go for a statutory appeal and come back to us. In the meantime, if they wish to, there is no question in keeping the matter pending.
It would be Caesar's to Caesar's wife. Tahsildar, they are
That phrase will not apply in all the cases, sir.
Formality.
What you are wanting from
I want this matter to be sent back to the Tahsildar, let a demarcation be done in respect of my property.
That has been done.
No, it has not been done. This is.
After then, let them file evidence, the present petition has been preferred. know, file.
Question number 3. WBA 199 of 125.
Content for the petition.
কত নম্বর এই নাম্বার এই নাম্বারটা ওই যে কোঅপারেটিভ yes what is this
Therefore, we demarcate.
you got that intimation
Yes, Madam. Some other surveyor can be appointed. Madam.
can be appointed
Yes.
we can record that
Yes.
acha acha acha. Just remind me what happened that, yes, what happened? What was the matter? You are the recorded tenant of,
At adjacent plot on the name is Sugata. He on 25th of February 2025, with the connivance of one surveyor, Mohammed Rasid, has put a pillar in the land of the petition. Thereafter, the petition.
where have you said that?
In the paragraph number. Well, it's the 24th of February.
You attended the said inspection?
No, was on duty all time.
Page 12,
Page 6, paragraph.
page 6, para 12. Where is your representation that you want demarcation?
Page number 7.
Page 17.
Page 17 and 20 is a complaint. Thereafter, I made an online application for demarcation. On the basis of this said application, a notice was issued. That is on page number 30.
Then what happened?
Same surveyor was appointed.
Then?
So, he came from that.
Then he came.
He came, but he refused to demarcate the land on the ground that Zubaida was not present. Adjacent property.
So what is the wrong he has done then, madam?
I already made a complaint against that surveyor.
Where is that?
Bias. Page number 17 for biasness.
Page number
Page number 7.
17.
Was followed by another representation that is on page number 20. 19.
What is the allegation? Allegation against the surveyor what?
That he in connivance with that Zubaida, he has instructed that Zubaida and he upon his instruction has put the pillar beside that.
Affidavit of service file করেছে? করেনি।
Like there is short pass.
Why you can file it? আচ্ছা ওনার নাম give her name. Learned advocate appearing for the petitioner submits that the petitioner is what is the next stage after the inspection and demarcation? What is done?
This land is jointly recorded land, there is subdivision.
Very good. You take follow-up steps. Yes, next.
Item number 4.
After demarcation, he has to file that to the tehsildar.
Yes.
Then thereafter, he is required to draw up a proceeding.
Objections.
That will be considered.
This area. Authorized and moved the land of somebody. Like, it just.
Follow-up steps there.
Doesn't problem.
Yes.
And I appear for the petitioner. Because this is against supersession of the managing committee of a cooperative bank. Now, the 3 dates are very important, apart from other things. But as a lordship knows, these
have Mr.
Yes, I think one other thing.
Yes.
These cooperative banks, as a lordship knows, these are run through managing committees. And which is an elected body. But please note 3 or 4 dates. 8th of March 2015.
Yes.
Where the elections were held. Term is 5 years. Various other proceedings were initiated. I will not trouble your lordship with that. But we are concerned with a show cause notice, which was issued on 12th of April 2019.
Show cause for supersession, administrator.
Yes, for supersession because of certain allegations. Yes, show cause was made.
For supersession of the board of directors.
Managing committee, as they call it.
Yes, then what happened?
Then the next election was held on 1st of March 2020.
It was not superseded.
Not superseded. That is pending.
Oh, that is pending. Now, 1st of March 20, new managing committee came.
1st of March, new managing committee comes in 2020.
1st of March.
1st of March.
Yes.
The impugned supersession order is on 10th of June 2024.
Which managing committee has a tenure till 25?
Which, yes.
Now, this further, this is 10th of June 2024 is again a notice for supersession.
No, it is a supersession order. Or the managing committee has been superseded.
Supersession, by the time it was passed, the managing committee existing on the date of issuance of show cause has lost its.
This is my point. That whether for the defects and defaults of a previous managing committee, whether the subsequent managing committee can be superseded. This is the point. My respectful submission is that the subsequent managing committee cannot be superseded for the purpose of or on the allegations against the previous managing committee.
In 10th of June 2024, the allegations were against whom? You were at the
managing committee.
Now, what sort of allegation? You are the new managing committee.
I am the new managing committee. Before I came into existence,
there were certain allegations against the earlier
managing committee for which a show cause notice was issued prior to me coming into effect. Me means the present managing committee or the last managing committee.
So your contention is for their faults I cannot be held liable.
Right, because there is no further show cause notice to the new managing committee.
No, this 10th of June 2024.
That is the order superseding.
Oh, achha.
But this is the yes. This is the order.
Prior to that, no show cause was issued to the new committee.
Right.
Very good. Then what happened?
There are various dates, I think for the purpose of interim order, these 4 dates are important. It has a long trail of litigation notices.
Then what happened?
No, I can cut short the matter subject to what my learned friend says. We were litigating before the Supreme Court.
In connection
with the show cause notice dated 12th of April 2019, where initially we filed a writ petition before this court. We did not succeed in the writ petition. We went up in appeal before the division bench of this
petition challenging what?
show cause notice 12th of April 2019.
That is previous mining authority.
Yes, which was issued to the previous mining committee.
So challenging that show cause you went to Supreme Court.
Up to Supreme Court, but not succeeding before this honorable court in the single bench as well as in the division bench.
So show cause was upheld.
Not upheld, not upheld. By single bench, writ petition dismissed, saying that you go and reply. Division bench also dismissed, saying that you go and reply.
Take all points.
And take all points before the show cause authority. Then when we went to Supreme Court grants me a relief saying that whatever you reply to the show cause notice, but whatever decision is taken will not be given effect to without the leave of the Supreme Court.
So was that order?
Yes, but no, this order your lordship will find at page 133, 24th of July 2023.
That is prior to your coming.
No, after coming. I came into existence on 1st of March 2020.
Oh, acha. 24th July 2023 Supreme Court order.
Yes.
Page
133.
So that was why that you have come. Yes, 133.
Yes, please take me at page 134. But initially where the show cause was stayed, I am not troubling with
but ultimately your writ petition was dismissed. You have come.
Yes.
Means the new managing committee went there.
Yes.
Not on merit.
You did not raise this point, those allegations are against them.
Yes, I have raised that point that has been rejected by them in the supersession order.
No, you didn't tell to the Supreme Court that this itself is not.
Because all points were permitted to be taken in reply to the show cause notice.
This dispute has
No effect shall be given to the order as may be passed. Time to file reply before the registrar by the petitioner shall stand extended by a period of 2 weeks from today.
Effect shall be given to an order.
Yes.
That order ultimately passed on 10 June 2024.
Right.
Then
I reply to the show cause notice in terms of the direction of the Honorable Supreme Court. Then they passed the order at 10th June 2024, which your lordship will find at page 193. Now this order, the order for the president. I'll come back to the order. The only sequence of the litigation, if to just tell your lordship. Now, they file an application before the Supreme Court, praying for a leave to give effect to this order of supersession of 10th of June 2024.
After the same was passed.
After the same was passed, but not communicated to me.
Where is that order then?
Yes.
Supreme Court.
Now, the Supreme Court's order is two orders made I need to place before my lord, 24th of February 2025, which is at page 272.
200. Two piece of paper.
No, there is a second one. I'm so sorry, man.
Page 222.
72.
272, on 24th of February 2025. May not be that relevant, but just I wanted to just read it. Now,
So this is in the SLP preferred against the division bench order of this court that they go and participate in the process.
Right. That senior counsel appealing for the applicant appellant states that the term of the present managing committee will come to an end at the end of this month. he states that now the first respondent will have to appoint a returning officer and an election officer. To enable the learned counsel appearing for the first respondent to take instructions based on such and such date. Then we are on the returnable date, kindly turn the page 274. Now, the Honorable Supreme Court is passing direction on two applications. One,
Mr. Doctor, I didn't follow this. Page 272.
Yes.
You went and told the Supreme Court my tenure is coming to an end.
we did not say.
Who said this? This managing committee?
No,
Learned senior counsel for.
no, I said. I'm so sorry. We had said.
So you said that my managing committee is due to expire. So you appoint a returning officer and election manager.
Because since the tenure was coming to an end on 25th of January 2025, I write to the authorities that our term is coming to an end. So please appoint a returning officer and an election manager for conducting the election. That is why this came before the Supreme Court at the time of argument, because we had filed two applications. When we filed this letter of 25th of January, they give a reply saying that the matters are pending before the Supreme Court. Therefore, we filed an application
to conduct the election.
They had filed the application that allowed me to communicate the supersession order.
Oh, I see. That application is page 274.
Yes, 274 is
Both
applications.
Which is the 14614 is their application
Yes.
for direction.
Second one. Yes.
Number double.
Your number is
2024.
16049, right?
So there.
Other way.
Other way.
4 is administrative.
So 16049.
Yes.
Yes. 16049 instead of 24 is my learned friend's answer.
What did you make? That you
To publish the order. To give effect to the order, because Supreme Court had injuncted us from giving effect to the order.
give effect to the order of supersession.
Yes.
Yes.
48 prayers.
And in reply to them, they said that our term is coming to an end of March. So direct the applicant to appoint a returning officer.
Right.
Then to enable the learned counsel appearing for the first respondent to take instruction. Who is this? First respondent.
First respondent is my learned friend's class.
Give effect. Respondent means you are the RCS.
Yes.
Yes.
Then what happened? An application 461.
I am 160490.
No. That is theirs.
Oh, that is the one. Sorry, this isn't. Yes, 2024 application is theirs, 2025 is ours application.
4615.
Yes.
Our number.
Then what happened that?
Well, on the next day, that is at page 274, that is 7th of March 2025, the Honorable Supreme Court was dealing with both the applications. Now, the first application is our application at page 274. IO number 46154 of 25 is our application. We direct the second respondent in these appeals to take all possible steps in terms of the regulation and the rules and the registered bylaws so that the election of the managing committee can be held immediately. Necessary appointment of officers shall be made immediately. The application is disposed of. This is on my application. Now, on the application of the administration, the next part of the order is we grant leave to the first respondent to give effect to the order of 10th of June 24. However, the said order shall not be enforced for a period of 6 weeks from today to enable the concerned parties to challenge the same in accordance with law.
Because by the way, the order was passed.
So, Mr. Doctor, what purpose will be served by giving effect to that supersession? You are in fact leaving the office.
Yes. Therefore, Millard, if my learned friend agrees, Millard, the elections have been fixed on
16th of April.
16th or 14th of April.
No, 16th of April.
16th of April.
13 casting. Results will be.
But I was only praying to cut short the matter. But the Supreme Court has granted me stay for a period of 6 weeks. If this interim order can be extended, say, for a further period of 4 weeks, but in the meantime, the elections will be over, and we can litigate before the Supreme Court in respect of the new matter, because the SLP is pending.
But what remains in that? All is in.
What I may submit, my lord.
You are,
Actually, I have the response.
you are not cutting it short.
No, I am also, I'm just adding to that, my lord. My lord, what has happened is, my lord, if my lord sees the impugned order, which has been challenged in the writ, no consequences are provided for in the order. It is only that supersede administrator appointment. So now that the fresh election is in any case being held, that order has been, to that extent, my lord, the order doesn't say that you will be prosecuted or you will be, any further steps will be taken. As of now, my lord, nothing has been done.
No, what prosecution? Your time is coming.
Term has come to an end. So, my lord, to that extent, my lord,
So, I shall record that I have been informed that the election of the bank is scheduled on 16th of April 2025. And in view thereof, the interim order which was extended by the Supreme Court shall stand extended for a further
I am
period.
submitting, my lord, there is no cause of action for extension of interim order, my lord, because
But
no steps have been taken.
when the Supreme, yes, we understand that, but the Supreme Court has intervened at that stage. How can I sit in appeal over the Supreme Court and say that no purpose will be served?
No, because my lord, Supreme.
I understand your contention that what will be the effect of that letter of June. Now the new election is a question of putting in an administrator does not arise in view of the facts and circumstances.
Yes.
Then you withdraw that, finished,
No, there
everything
is,
comes to.
that order, my lord, is appealable. There are other points, my lord, that we have.
So that
And
will
the
be an
main
exercise in futile, Mr.
No,
Chakraborty.
because my lord, the main contention in the writ petition is that part 9 of the constitution should be followed. Now, my lord, Supreme Court has decided that that is applicable only to multi-state cooperative society. So there are,
That's a separate issue.
I am not getting into that on the merits, but only submission today, and my lord, the petitioners have filed without any authority from their respective societies of which they are members. So, my lord, there are several issues, my lord. Those points I'll reserve, my lord, for affidavit. I'll take those points. But my only submission, because subsequently they had filed a writ challenging this order.
Which order? Yes, but I have only one point is 11 June.
Yeah.
No, 10th June.
Yes.
Yes, what we did is, but only one point that I was left to apprise the lordship with. The Supreme Court grants me liberty to take approach the appropriate forum. Milord, since Milord, according to us, Milord, Article 32 was available to us. Milord, we approached the Honorable Supreme Court in an Article 32 petition. Which is at, the order is at which 297. After the Supreme Court said that it will be open for you to challenge that.
Yes.
They were 297.
297, yes. I'll file a section Article 32 petition.
Challenging the 10th June.
10th June. Because Supreme Court has granted me leave.
Very good.
Now, here the Supreme Court
now says go to the writ court.
Yes. Therefore, we are coming before your lordship today.
But Mr. Dotto, what remains in?
No. Yeah, I have to get rid of the findings that have been arrived at in the supersession order. But the supersession.
By the previous board members.
Now, how do they entangle me? How do they entangle me? I mean, the present management committee. Will please take me out the last page of the supersession order at page
241.
241.
Now, this election issue was told to the Supreme Court.
See, in a roundabout manner, told, because that is why Supreme Court wanted to take instruction as to whether the term is coming to an end or not. That is page 272. I have shown to the lordship.
Yes.
Kindly see the first line where counsel appearing for so and so states that the term of the present managing committee will come to an.
Doctor, wow. What are the allegations that you will be affected?
Yes.
Last week, they can, if they are aggrieved, they will issue a fresh show cause notice to you after the new managing committee takes. Mr. Chakraborty is right that he need not expect that at this stage we will take any other steps on the basis of 10 June.
But that is why I wanted to cut short the matter. They extend the interim of the Supreme Court And your lordship will keep the letter pending because I need to get rid of this finding. Which finding? Only one page. Can you have a look? The other things we have, whole how we will deal with that when the matter comes up before lordship at the final stage, where the last page of the supersession order.
241.
Page 230.
241. Please take me at page 241.
The last paragraph.
But we have taken the point which I am urging today, that how can we supersede the present managing committee for the alleged misdeeds of the previous managing committee. We have taken the point which is being dealt with over here, that page, in the 49th page, that is page 241. Please take the middle of the page, the sentence, therefore the charge number for 23 stands valid thereafter. And whereas on examination, matters found that examination and after due consideration of the documentary evidence available and the reply furnished by the bank to the charges in the show cause notice dated 12th of April 2019, it is found that the replies are not convincing and satisfactory, and in some cases even factually incorrect. The bank has further taken a plea. This is the point. That the show cause notice was issued to the previous managing committee. But I was reading the fifth line of that paragraph.
Yes.
The State Cooperative Bank Limited, Port Blair has further taken a plea that the show cause notice was issued to the previous managing committee and the action of supersession cannot be done on the present managing committee. This point was taken. The present managing committee elected on 1st of March 2020, comprising of 10 members, out of the 7 members, that is, the names are given, after assuming office, did not initiate appropriate corrective measures to rectify the charges framed in the show cause notice dated so and so. And the irregularities pointed out in various reports forwarded to the managing committee of the bank from time to time. As such, the present managing committee of the bank was also found negligent in the performance of its duties mandated on it by the bylaws of the bank and the regulations rules, and indulged in acts which were prejudicial to the interest of the bank and its members. Now, therefore, in larger interest of the bank and its members, I, so and so, registrar of so and so, in exercise of powers conferred under section 21 of the regulations, do hereby order for supersession of the present board of the managing committee of so and so bank and appoint so and so as administrator. So this couldn't have been done. There is no show cause notice to me or the present managing committee that you are negligent or that you have not rectified the irregularities which were pointed out against the previous managing committee. That charge has to be brought against me. Now they say their ground is 7 out of 10 are saying
Doctor, but for that,
yes,
the new committee will not be affected in any manner. The which is coming upon election, the new committee which is coming, that will have no effect on this.
Milord, technically it has effect. Why I tell your lordship? Because I have to, Milord, shown by
Supreme Court chapter is over.
No. Supreme Court pending.
Those 2 applications.
So applications are gone, but Milord, the SLP is pending. Against the show cause notice. Against the show cause
division bench order.
Yes, division bench order. Which arose, if I succeed or don't succeed before the Supreme Court finally, that will be connected to the 12th of April 2019 order. Show cause notice. Therefore, the show cause notice
29th June 24.
No, that is 10th of June is a result of 12th of April 2019.
What is that?
What is the first date, the third date that I told to a lordship?
Focus notice is practically the charge sheet in this.
It is so complicated.
Yes, that's right. It will take time in a long history. So to make it simple, I challenge the validity of the section or section 27 under which this action has been taken also, because it's contrary to part 9B of the Constitution.
So what do you say, Mr. Chakraborty?
So far as the first point is concerned, the show cause.
I am not recording anything. I will only say that we have been, I have been apprised that the election is scheduled on such and such, and I have been shown that Supreme Court passed an order of 6 weeks. In view of these things, as the election is there, I will keep the matter pending, come to the next division bench, next circuit bench, and the interim order we shall extend for
No,
that.
I'm only submitting my note, and because I'm submitting under instructions, my note. The difficulty is the original show cause notice of 12th April 2019 is under challenge before the Supreme Court, because those proceedings have travelled up to the Supreme Court. Now, the final order.
No, 12th April as well as this order is under challenge.
No, this is challenged before
Your Lordship, 24th of.
the show cause notice is challenged before Supreme Court. And the final order is challenged before your lordship.
By leave of Supreme Court.
Now, the difficulty is, my lord.
Now Supreme Court says that you challenge that order.
Says you challenge, my lord, but point is, my lord, eventually there has to be some cause of action for an interim order, my lord. Today, my lord, no steps have been taken against them pursuant to
The
this order.
situation is the same when Supreme Court intervened. Supreme Court in appreciation of appointment of returning officer says that don't take any step. That was the instruction sought for on your application.
Yeah, they want it.
So Mr. Chakurti, what means?
I am only submitting, my lord, I have a suggestion, my lord, please comment. My lord, today if there is some action taken, my lord, we grant them the leave to approach the court if some steps are taken. Because honestly, this order is the legality.
That will create multifariousness. A litigation is pending from 2024 April prior to that.
Election, they will use this to say that the High Court has stayed this order.
No, I shall say that I will specify the date. You thresh it out before.
In any case, Supreme Court order is there till 26th April.
No. 16th of April. 16th of April.
16th of April. Order is there.
On the day of the voting.
What interim order you have put it for?
Two of this.
Final relief, my lord.
How can I file? The Supreme Court has granted no final relief.
The Supreme Court only granted to enable them to approach the High Court. That is it. There has to be some irreparable loss.
Check my fishy case, definitely. I have the application. I will definitely discuss
Seven
that.
people, my lord, who are common. At best, these 3 people were not issued show cause notice, who are the petitioners here. Out of 10, 7 were issued because 7 were there in the earlier committee. Now, those 3 people have filed this petition, my lord. They are not prevented from participating in the new election. There is nothing in this order which causes any kind of prejudice to them in that sense. Yes, if some further steps are taken, like prosecution law.
That Mr. Chakurti, how can we decide today? We don't know who will be elected. If certain new persons are elected against whom there is no such allegation which Mr. Dotto is harping upon, automatically we will stand.
These people can still be elected again. They are not prevented from participating.
No, we don't know who is going to be elected.
But today, my lord, there is no consequences of this order, my lord, which is challenged. Only it is being assumed that some steps will be taken against them. Today, there are no steps taken. Now, if it is purely on the legality of this order that part 9 of 9A of the Constitution is applicable, which according to us is not applicable in view of the Supreme Court judgment on the subject, but assuming it is applicable, it will purely turn on the legality of this order, my lord. There is no cause for interim relief. Because there is no. But that is
No, Mr. Dotto, কিসের আওয়াজ হচ্ছে? No, suppose this order of 10th June, how can it be given effect to after the in this fact scenario?
No, on 16th it can be.
10th of June says that I want to appoint one Mr. Azaruddin as the.
I have not appreciated one contention of my learned friend. If he cannot do anything, then what is the difficulty in the extension of the interim order?
May I then suggest something, my lord? I'll support my lord.
In the interim order, I will record your statement that no administrator will be appointed.
No, yes, my lord will say this. Just with the greatest of humility, I'm making a suggestion. Knowing that I'm before a lordship and in the presence of the sir, I'm submitting this. My lord may say that in view of the notice issued in the election, it is evident that at the moment there is no.
No, that leaves a gray area, na. Then I have to record your submission.
Yes, my lord may say that in view of the issuance of the election notice, it is evident that this order is not being given effect to. That my lord can, that is factually correct. Given that election is being conducted This order administrator is not being given effect to at the moment. Definitely it is not being given effect.
So you tell us, I will record your
No, that's
signature.
actually, man, it is enrolled.
Actually, many things. You say I will record, I will adjourn it. That
Then-
yeah, we have been informed that the next election is fixed on such and
Yes,
such
my lord.
date.
Yes.
And you upon instruction, you are saying that you will not be giving effect to this order.
No, my lord,
You will not be appointing any administrator at this.
Till the new vote comes. Pursuant to the election.
So I will
just
say
take
that-
him, give me one more.
Section 54 to May I submit one thing? I'm asking for the
Yeah,
respondent.
just one moment, Mr. Shivwan. Let us see what the instruction comes.
My lord may not record it as my concession, but now I'll give something which is my lord palatable. What I'm submitting is that in view of the fact that the election notice has been issued, it is clear that no administrator will be appointed. My lord may find record.
That I will know, they will know, but how the state will say?
That is legally.
I have to record.
Say, my lord,
No,
my lord may.
I will say
My lord may
that.
say that, my lord.
No, no, I will say that, and I will add this, that this is your instruction also.
No, my lord, it is a legal, that can be part of the interim order, in fact. My lord may say that because the election notice is issued.
So that
there
it
is no
boils down to,
appointment of-
exactly, it boils down to the same issue.
My lord may not say, I have submitted on instructions, my lord. That will have some consequence. My lord may pass it as an interim order. That since the election notice has been issued, so therefore administrator cannot be appointed. My lord may say so. My lord may pass it as an
I
order.
can say that there is no possibility on record that there will be an administrator appointed.
Be done because election is being held. So how can administrator be? Because my lord, without as a government council and even government officer present, my lord, they cannot be. If it comes that they are saying it on instructions, people it will create problem for them individually.
No, I will say that there is no scope for the appointment of an administrator during this interim now. And accordingly, I will direct that there will be no appointment of administrator.
Yes, that my lord.
Ashok.
One more sentence, Millard. Where there is scope of taking further steps, like such as proceedings, there are other proceedings which can be taken pursuant to this order.
To at the face of the case.
You also be there.
That is that within this time, how can it be?
Sure, such a notice.
Nothing is being done at the moment. Sure, that will give an impression as if my lord has applied your lordship's mind to the legality of this order. My lord may not say so. My lord, they can.
The best thing is to extend the interim order.
No, my lord, then the legality prima facie they have to make out a case.
I will make that case. I'm not signing.
I'm saying, or I can say with responsibility, no steps are being taken. I can say so, my lord, but it cannot be, my lord, that extension of interim order, my lord, may not be, my lord. My lord may grant.
No, I don't understand, Mr. Chakraborty, why this extension is troubling you. Because you are also saying that there is no
administrator. No
administrator. What about the other consequences?
consequences, my lord.
So in that case, there will be a misunderstanding between the councils and the court. Suppose today I record that and I say that I am not inclined to go into and pass a fresh interim order at this stage in view of such. Now tomorrow, if anything else happens, it will be multiplicity of proceedings. But you also cannot surely tell me, certainly I cannot record your submission that no step whatsoever.
Steps have been taken as on date.
I understand that, but the present writ petition has been preferred.
Number 5, WPA 196 of 125. Lordship, I am appearing for the electricity department.
My lord, I am appearing for the petition.
My lord, my senior, Ms. Sanjali Nag, appears for the private respondent that the matter be not today, my lord. It is just posted tomorrow.
My lord, the service has been effected 4 days back. The problem is that the private respondent locked my cow shed, my cows, my cattle are outside of my cow shed. He took electric connection, electric meter in my cow shed, which is in my occupation since 1987. 4 days back, it was, service has been effected. New meter. Remove the electric meter which was affixed by the private respondent in my cow shed.
Electric meter installed. They want private. You have a separate meter at your place.
No, cow shed, there was no meter at all.
So they.
Adjacent to that.
You are asking the respondent to remove the electric.
Yes.
Whose meter?
The private respondent installed the electric meter in my cow shed.
When?
On 3rd of this month.
At that time, your cows were not there.
My cows were in daytime. My cows were in grazing land. My cows were in grazing land. It was daytime. The police obstructed.
Done in the morning.
Yes, at 10.
Yes.
My lord, herein we acquired an order of this honorable court itself.
Land bearing survey number 316 and obtained electric connection in survey number 289.
No, my lord. No.
Yes.
Tomorrow.
Mr. Mishra is appealing for the electricity through on.
I am
Also-
appearing, Lordship. Lordship, this is the difficulty. When we will provide the electric connection, somebody will come and they will claim that this land is not mine. That land is mine. I am ready to disconnect it after the order of this honorable court.
Now, who will ascertain that it is a cow shed and cows are not being able
The
to?
writ petition has been filed by the private respondent and I was not the party. First instance, Mr. Mishra submitted before the honorable court that land in question is under my occupation since the year 1989, the 87. The private respondent is not in occupation of that particular land. So subsequently,
Why do we know that?
and
But
the
even if it has been done, that does not create any right in her favor for the land in question.
this way he disposes me from.
I will pass an order regarding that.
Yes.
Finish. As a lawful owner in Obhimanyu Majumdar, what was said, sir, that even a lawful occupier can enjoy, irrespective of the.
Look up.
But in settled possession, Lordship.
But this way I will specifically direct that this
I will make my submission. Only the
Acha.
civil suit is pending. The authority,
I will come tomorrow.
Tahsildar first focus notice that that particular land is under my occupation.
Show us that all.
Yes, that is there. I have enclosed.
Don't take adjournment tomorrow, sir. Circuit will be. Yes, next.
Item number 6.
My lord, this is an application they have filed for grant of water connection. As my lord has already passed an order on Friday.
ওটা জানো ওই মনোজ ওই একটা কি অর্ডার ছিল না ওয়াটার
That's. Yeah, my lord, they have not submitted the document. So my lord has passed an order that they will submit the.
subject to comply.
Yes, yes. The area is same, but the survey number is different, I suppose.
Can you give us the survey number?
Yes, yes. This is 100 by P, my lord. The application number and application date.
You will water connection if you put water connection it will come I think. হ্যাঁ দেখো তো
রুনা খাতুন ম্যাডাম।
কি ফার্স্ট প্যারাটা দেখো তো কি লিখেছি? The present writ petition has been preferred. না না কপি বের করতে হবে না। The present writ petition has preferred inter alia praying for issuance of necessary measuringটা দিতে হবে না। Situated at
আফ্রিকান
situated at near Patwadi office. Sorry. Yes, I give. On you submitted an application when?
6/3/2025.
6th March 2025.
Yes, Lordship.
Mail कर देता हूँ। March 2020, but he or she,
He, Lordship.
अच्छा, he submitted an application bearing number
6035.
6035 along with an affidavit to the competent
Yes.
authority paying for grant of individual water supply connection. In spite of receipt, the respondents have maintained the discipline.
Yes.
Acha, Mr. Rakesh Kumar enters. No instruction is why the applications are on here disposed of. No useful problem. Same needs to be relegated. Allowed petitioner's application dated such and
Yesterday evening only I received the, it will be on Friday, Your Lordship. Item number 7.
let it be tomorrow, madam.
There is a possibility of settlement also between the parties.
It can.
Because-
Without it also, yeah.
Yes, many matters
Oh,
are
I
here, that's why.
All right.
Let it be on Friday.
No, that is the last date, na. That is why I was wondering. Anyway,
Possibility not, very possible.
all right. And Friday রেখে দিও. That is item number 7. Yes, next matter.
Your Lordship, one request, Your Lordship. Item number 26, Your Lordship, but there is some urgency. And this honorable court has already expressed Your Lordship's opinion with regard to appointment of arbitrator. Unilateral arbitrator appointment, Your Lordship. Your Lordship, remember, there is an order.
What order do you want from us?
They-
To agree between the parties?
Yes, Your Lordship, any judge of this honorable, retired judge of this honorable court may be appointed.
Then the warrant has to be cancelled, mandate has to be cancelled.
That has to be, Your Lordship.
Why?
My lord, we can't agree to that. We can, my lord can appoint that judge.
No, for that I have to decide, na, set it aside is a long drawn process.
But the problem is that, your lordship, this present arbitrator is continuing with the arbitration. We are in
My
difficulty.
lord may consider.
Ultimately, your lordship, we both will be in loss. Otherwise, interim order may be passed.
Interim order can-
When is the next date?
Today,
He's our appointee, my lord, we cannot. Can I say, my lord, our- appointed by the department.
unnecessary expenditure will be there by both the parties, your
Okay,
lordship.
the department. Only point of distinction was that judgment which has been signed, the full bench, the Supreme Court has decided the issue. That was in the context of a 3-member.
No, sole arbitrator also.
Sole arbitrator does not find bench, but I am not
It is there.
strenuously arguing that point, I appreciate, but
You tell your arbitrator not to proceed, finished.
how will, we are both participating in those. Can't say that.
So you take an adjournment.
No, but he's proceeding, even Ms. Nag is appearing before.
I have requested him not to proceed, but he is still proceeding. I have requested him, the matter is pending before the High Court, even then he is proceeding with the
My
matter.
lord may then, my lord may consider, my lord, directing the parties to make a joint, that parties will jointly request the arbitrator not to proceed, something like that.
What
Direction we can do.
no, what will the arbitrator say thereafter? I either have to mandate or I have to.
My lord is not
No,
decided.
I was thinking instead of going into an antagonistic controversy, if the matter can be resolved, why invite a judgment? That gentleman, he also,
He has passed an order, my lord, how will, he has passed an order.
He says
That he has jurisdiction.
no, there is no
How
doubt
will
of it.
we get over that, my lord, unless your lordship passes?
That Mr. Chakraborty, don't tell me that how the advocate will explain this.
Yeah,
If anybody comes and anyway, I need
my
to.
lord, we have argued before him that he has jurisdiction, my lord, how do we now say that you don't have jurisdiction?
Because of the court,
Yes, so my.
because the
lord
court is desirous.
Yes, my lord, so my lord says that.
The earlier bench has said that it is there, then we will detect, don't fix a date.
Yes, my. Fine.
When is the next date given?
today, your
Yes,
lordship.
5 o'clock.
Today, 5 o'clock.
All right, very good. You say that in view of the previous bench's order, the matter is, you take an adjournment.
No,
also.
please agree to what Ms. Mark said. Khuda.
You say that the list is such that the matter cannot be immediately taken up. So the court has, the last bench was desirous as to whether this can be meted out. But if the learned arbitrator thinks that he cannot unnecessarily, I should not make this, it is for you to
I
say.
know, your lordship, but
No, I will.
Why you-
You pay for a date on say June middle, I will keep it on a date
I
thereafter.
will cooperate, I can say across the.
To fix, as the court is in CC, you fix it after 16th or 17th.
the instructions, last order is there. Justice, yes.
Yes, last order I have seen Justice Sen has passed an order.
क्या order था?
What do you want to know, Mr. Chakraborty? You want to see the order?
Yes, my lord, I will see it on myself online.
पेश होगा देखिए तो होना के ऑर्डर था. That was by Justice Sen, na?
No, then this will suffice. This order was perhaps neither of us have placed it before the arbitrator.
Yes, court has said.
It was not the- because this.
No, this will suffice. This can be.
Mr. Chakraborty, you say that you know what is to be
Yes,
done.
this order will suffice. I'm sorry, we are not.
Miss Nag, you go to them, if the date is fixed on that, very good. Otherwise, then we mention it before us, we will keep
No,
it on.
once Ms. Nag places this order, I'm sure the arbitrator will also. not proceed. This
Yeah,
is-
I'll do that today.
You do it, and if per chance in difficulty arises, you come and tell me.
Yes.
With a notice to Mr. Chakraborty.
Yeah.
My lord, it-
Obliged.
Yes, item.
Item number 8.
I do not want to unnecessarily create any sort of embarrassment.
Yes.
Therefore,
We are nearing to the last days, and even if interim order is required to pass, the lordship has to pass a very detailed order.
detailed
This
order.
will be
that-
practically disposing of the.
And care. I think with the good office of Mr.
Yes.
Chakraborty, you would. Yes, next.
Item 8, WPA 2025. Your say I on the, it is a case of heinous injustice
on the part of my client. My client admitted to the GBPAN as a mental disorder patient. He was referred to the NIMHANS at Bangalore. He had gone there Bangalore, but he had not accepted. My client by the Ayushman Bharat card holder, free a cashless treatment up to 5 lakhs. But the
Have you served upon the respondents?
all this is service.
Yes, Mr. Chakravarti, are you there?
Received instructions, my lord, but if it is copies given to Mr. Kumar, we can take.
What, you want treatment money?
Treatment.
Who will give it to you?
The director of DHS.
Have you made any representation to him?
You know, page 7.
Page
7. Yes.
Page 7.
Yes, sir.
Are sir, what you have said? NIMHANS is a central government hospital. Central hospital? Huh?
Yes, at Bangalore. At Bangalore.
To what do you want, sir?
Sir, DHS respondent report referred me to NIMHANS for.
Where is that letter of reference?
Page number 9, you know, P2 in Excel P2. Office of the Medical Superintendent, Jipal Hospital. Summary of the case referred to the mainland. This is the referring certificate, and on the basis of
Just where is referred to mainland? What is that, sir? Page 9?
Page 9.
Where referred?
Mainland.
Where it is written?
Page number 9.
Yes, 9. Where it is written? Referred to mainland?
Summary of the case referred to mainland. There is a fourth line. After
Yes. Acha. It was mainland, you went to Bangalore.
He has told me to go to Bangalore, NIMHANS.
He has not told you.
This is under the instruction.
Very good. Later on, so after this, you went to NIMHANS. You got admitted there. Then what is the problem?
Then they
paid money for.
They have not given me free treatment. On the basis of Ayushman.
Now you have come back from NIMHANS.
No, I have come back from NIMHANS by paying my own money. So I want.
Now the director will have to pay you.
Because I had Ayushman Bharat card holder, and under this card, up to 5 lakhs free treatment. I'm entitled for that.
Where is your original card?
Original card is with me. I will produce tomorrow. If the respondent 6.
You should have made a proper representation, sir. You are threatening the authorities. What they will do?
You don't see. It was a heinous injustice. My client go there.
We appreciate, but you are showing
great pain with my client.
Mr. Chakravarti, see, take instruction if anything.
Give a copy, my lord.
Give a copy to your friend. Not today. See if anything can be done.
Let him give a copy to
Mr. Chakravarti, he will make a fresh representation along with his Ayushman card, anything. In terms of the Ayushman card, you'll take a decision.
Examine what scheme there is, what is the extent of reimbursement where you're referred to a different hospital.
Your lordship,
He's ascertained that because unless he gets those material, he won't be able to apply properly also.
Your lordship, I have applied proper. There is no any lag.
We have spoken to Mr. Chakravarti. Just relax, wait, let us see what comes. This way it cannot move.
Item 9, WPS 21225.
Tomorrow, because in the notice I have given for tomorrow. Take it tomorrow.
Sure.
Number 10. WP 161/25. Hello, Chairman, update for the petition.
I am representing the respondents.
The last occasion, there was a direction to file evidence opposition by the respondent, but there.
No, my lord, there was a direction to add the additional Solicitor General.
We have dispatched it, but there is no tracking report to the end. The views have not been affected.
Service has not been
Affected
effective.
to the additional solicitor general.
You have not done so.
We have dispatched it, but not yet received. The tracking report not.
Next circuit.
Right.
Obliged, my lord.
Item number 11, WPA 176/2025.
Yes.
I am for the respondent.
The authority has given with the, they have assessed the premium, they have given with the.
We have implemented.
But fully, it has not fully implemented, because there was two orders. First order has been implemented.
Yes.
Have paid the premium. Now, the next thing is, my lord, the creation of the tenancy, that is the record of rights, and the sketch map has to be given to me, my lord. Just, it's at page 24, my lord, last order. But this is, summons. There was two part, my lord, in this. They have complied with the first part.
No, we have complied full, my lord.
No, my lord.
Only one paragraph.
Tenancy in favor of the writ petitioner. This has not been done, my lord. So I have to given with the records of rights and the sketch map, my lord. Otherwise, again, I have to file a writ petition. Because earlier was same thing happened, my lord.
My lord, this is the order passed by the
Yes,
Deputy Commissioner.
I have received it, my lord. I have got the copy. I have paid the challan also, my lord. The premium I have paid it, my lord. Now they have to create a tenancy.
Are sir, madam, I am hard. I am not hard of hearing. You don't have to repeat 10 times. But Mr. Shivalan, his lordship directed that one was about assessment of the premium, and the other part was that you have to record the surrender of such excess area and grant tenancy in favor of the premium.
My lord.
See the order, page 24.
Yes, my lord, that is the order. My lord, it will.
She is right that one part has been complied with. The next one.
Yes, my lord, after she has paid the amount, then she has to oppose the Tahsildar.
No.
No further, there is a composite deduction.
Yes, my lord.
And you are disposed of without considering that portion.
No, that is.
This order.
First they have to pay the premium.
They have paid.
Yes, now only they have paid. So it is the follow-up action after that. After they deposit the premium, only thereafter land record has to be corrected. They have paid the premium
I shall
recently.
record your contention. But one problem he has done, he has disposed of the representation.
Yes, representation disposed of, on that the challan has been issued. After that.
And then what about the recording, sir? That has to be done, na?
Yes, sir. After disposal, they have been issued challan. After that, they have paid the premium. Only after that, only the subsequent action can be taken, my lord.
When did you pay the challan?
Hello, Monday. Friday they have given, I have paid it on Monday.
Monday.
This Monday.
This
This
Monday.
Monday. They have given.
Receipt you have.
Yes.
Even on Friday, no, paid on Monday.
Again, it has to be kept pending, no?
It has to be kept pending, my lord. Otherwise, they have to give by Friday, my lord. Or it has to be kept pending. Because what had happened, my lord, earlier also in one case, first premium was has accepted. There are.
Or we can file opposition by enclosing this order.
How we can file?
I shall record that he has paid the premium has been determined.
Yes.
Paid the premium, and I will record your submission that necessary follow-up steps will be taken. Recording that, I will keep it in the, can it be this?
Next circuit.
Excess land has been surrendered, premium has been paid.
Yes.
So there does not appear to be any hindrance towards compliance of the other part of the order.
No.
It has to be kept pending.
Yes.
Miss Jeannie Learned Advocate appearing for the petitioner submits that the earlier writ petition preferred by the earlier writ petition preferred by the petitioner was disposed of on 24th November 2023, directing the authorities to assess the premium of the licensed land, LICN ACD. And upon recording the surrender of the excess area, records reveal that that in an earlier writ petition, an order was passed on 24th November 2023, directing that, quote unquote, ये portion quote unquote italics. Miss Jeannie Learned Advocate appearing for the petitioner submits that the license amount was assessed and intimated to the petitioner. When was it? Challan was drawn when?
Friday.
Intimated to the
The
petitioner
last page I have sent.
on 4th April 2025. And accordingly, when did you pay?
Seventh.
And accordingly, the said amount of rupees 11,200. And accordingly, the said amount was deposited by the petitioner on 11th April 2020.
7th April.
7th April. Mr. Shivabalan, Learned Advocate appearing for the respondent submits that the necessary follow-up steps Mr. Shivabalan, Learned Advocate appearing for the respondent submits that the amount has been deposited only on 7th April.
But after they submit the receipts to the
Same day.
department.
Same day I've submitted.
Yeah.
And that as such, amount is deposited on Monday and necessary follow-up steps will be taken. And necessary follow-up steps would be taken. In view thereof, list the matter for further consideration on 10th June 2025. 10th June 2025. On the returnable date, no, the records 10 June कर दीजिए.
Apply.
Then
Necessary follow-up steps would now be taken. Mr. Shivabalan, Learned Advocate appearing for the respondent submits Mr. Shivabalan would apprise this court about the follow-up steps taken
My lord. I shall, my lord.
by the competent authority.
Lordship, item number 12 to 17, it can be taken up tomorrow, Lordship.
Why? Why, sir?
Lordship, because this honorable court has directed me to bring the record in item number 12. Record is with me, but I have some personal difficulties, so I have not come before this honorable court. So let it be not today, Lordship. Tomorrow I will come and I will make my appropriate submission.
Not today. Take the motions. Yes, chalo take the motions.
19, my lord. My lord, my lord, that with regard to promotions, that Airport Authority of India, my lord.
Yes, Mr. Kumar, I have seen that Odisha High Court judgment.
Yes,
Odisha High Court judgment it appears to be filed by persons who are similarly situated with you.
my lord, I have gone through the judgment. The issue there is entirely different. Their case was that,
Then it has to be heard, sir.
my lord, I have concluded my argument, my lord.
Yes, I was desirous of finishing it.
Now also,
But
my
when
lord,
I saw the judgment, I asked her to take information as to whether any appeal is pending.
appeal is filed, my lord. I have seen that. I am not on that. They are, my lord, two different categories.
That's very good. When the appeal has been filed, you await this.
My lord, that has got nothing to do with my case because in housekeeping division,
We will hear you. We will hear you. We will hear you about if the appeal is not disposed of, naturally the consequences.
my lord, I say that that judgment has got nothing to do in my case. Since, my lord, my case is that my juniors who are junior to me in the same category, my
Mr.
lord.
Kumar, you are junior, you are.
Assistant manager.
That's a file to down.
My lord, there are two parts. That judgment has got nothing to do so far as I am concerned, my lord. And I have brought the list. My lord has asked the others who are junior to me, who were promoted. You just give me the date when they were promoted. I have brought the list. I have already served a copy to my lord.
I have only one more day. I was desirous of finishing it.
My lord,
I tried my best because see, simple, this adjournment will not serve the purpose. I have to give my verdict, na? It's a question of promotion. Yes, but
I am going to retire on 30th of April.
that is also a case.
My lord, my learned friend my lord has asked a specific question to me.
Wait, let me come to page 70.
My lord. My lord.
Read the last paragraph.
It will be pertinent to mention here that the category of housekeeping person in elsewhere, NAA and NAD was merged with terminal.
Right, wait here. So there were two categories.
My lord.
NAD and IAD.
Yes.
You belong to IAD.
Yes.
That is metro section.
Yes.
So in NAD, there was a policy decision towards amalgamation of the two factions.
Yes.
One is the housekeeping and is the other is terminal. That were merged with terminal management discipline in the year 2003.
My lord.
And such and such. Now further later dated 7th May 2008. Whereas Mr. Prakashan was in IAD and hence he cannot compare his seniority with terminal management discipline. Now, please come. Now come to the first paragraph of the order which she brought.
My lord.
The issue is same and identical. Let us, subject to correction by you. I may be wrong.
My lord.
The petitioner through this petition seeks a directive of this court for the integration of housekeeping of the integrated airport division. This is your faction.
My lord.
Into the terminal management operations department.
Yes.
In your faction. Aligning it with the organizational structure of housekeeping in the NAD.
Yes.
How aligning with this organizational structure? What was the organizational structure? Merger. Furthermore, the petitioner requests the seniority of housekeeping staff in IID, as you are claiming, be maintained and recognized within the seniority framework of Operation Terminal, which cannot be done since there has been no merger in IID.
Yes.
So unless this issue of merger has been decided against you by this judgment, so unless this order is upset, question of your grant of claim does not. If you want that, I will.
There are two parts. This is one part of my argument, which my lord has rightly pointed out, that this judgment, unless and until it reaches to a conclusion, it cannot be. This is one part of my argument. Second part of my argument was that those who are junior to me in my division, that is the International Airport Division, they were promoted. Timely promotion was accorded to them, and now they are sitting to the post of Deputy General Manager.
Their entry was much later.
Housekeeping.
Their entry was much later. Yes. Your grievance is with regard to that Anand.
No. Anand, my so what has been fallen from my, it's absolutely correct. I leave that.
That Mr. Kumar, I have not found any paper subject to yours pointing out that so far as the subsequent appointees are concerned.
Well,
Subsequent, then I have to receive the data of that. I cannot just deliver a judgment by the drop of the
I
hat.
have brought the data. Already the documents are placed in affidavit in reply. My lord has seen those documents. My lord has made a query to me to tell me on which date those
Yes,
were
yes.
promoted to
Now
the post.
this, sir, this which you have annexed here,
Yes. Page number 22 onwards. my lord.
page 22, kindly come.
Yes.
Provisional seniority, last page.
22 onwards. my lord.
Kindly come to page 24.
My lord.
That is in the assistant manager HK hierarchy. Their names do not feature here.
Their name, because by that time, my lord, there are three lists.
No, their name, why should it not feature in the seniority list as on 2023?
Because they were already promoted to the post of assistant manager, deputy manager. I have brought that list, my lord.
Yes, when? The promotion of this Lakra.
Yes. My lord, this is the list already I have supplied.
Very difficult, sir, to understand this.
No, my lord.
I have.
Because my lord has given a considerable time to this matter, my lord. So
I understand, Mr. Kumar, but without it is a question of conscience. I cannot say I can reject your case on the ground of limitation, straight and simple. But when I found that the issue is being deliberated upon by a court, I thought that it should await the decision. Otherwise, I have to hear you and distinguish the judgment to hold in your favor. Please try to understand the difficulty. I spent so much of time with this order and I was desirous of delivering a judgment. But when it came to my notice, because this entire order, she was not in a position to place. I went through this order. And this order which has been delivered, I tried to find out myself itself whether this has been upheld or it is pending or not.
my lord, it was filed in the month of December, my lord. The appeal has been preferred.
So, Mr. Kumar, if it goes in your favor, naturally you get everything.
Let it be adjourned simply, my lord.
I am making it not today. If tomorrow also you can come with some fact, I am ready because I have hard substance. I am desirous of disposing it. Madam, I keep it as tomorrow. Let us see if any development occurs. Do you know the status of the appeal then?
Pending, we have got the internet.
No, I have got it.
You got it now.
Still there.
Ascertain from your client.
It's still pending, my lord.
Not today. Mr. Kumar, I had a small matter was being argued similar to this. There was a point involved wherein there was a division bench judgment, a full bench judgment, and then to Supreme Court. Very senior counsels were appearing. So I heard the matter. I started I made a judgment resound on the basis of that. The senior advocate, he told me. What happened to me? I just wanted to track the internet as to what had been the status of that before the Supreme Court, if at all they have approached. I found Supreme Court accepted it and rejected their plea. Next day I brought it as to be mentioned and asked the council that, sir, you should have, because otherwise my judgment becomes par incurium, that it is not. So I wanted to ascertain. Anyway, I am keeping it tomorrow. If Mr. Kumar, you can come with anything, we shall.